It is a lordship. I'm praying for listing of this review application, my lord, on Friday, my lord.
Review application.
Review application, my lord. Okay. I'm deeply organized.
May I please, your lordship? I need to pray for listing, my lord, or motion, my lord, tomorrow, my lord.
Motion.
My lord.
Subject matter.
Subject matter, my lord, the petitioner's fair price show has been seized by the executive magistrate without violating, my lord, violating the PDS
Okay.
of that.
May I please vote? I pray for listing of the IA lordship, seeking leave of this honorable court to allot the additional voucher to the selected bidders lordship. As these are- additional voucher lordship,
Additional.
voucher lordship, tanker. To oil lordship.
Friday.
Lordship, beg to mention item number 11 of hearing this lordship. No, I'm praying for some accommodation lordship.
You're for
I'm for the petitioner. The petitioner was an expert
petitioner.
petitioner.
Okay, you have informed the other side.
Lordship, I couldn't contact them. During the course of the I'll inform them.
Okay, Mr. S. Sogovri, Land Council. What is your region?
Actually, my senior, I lost my senior yesterday. I'll petition was expired.
Okay, Mr. S. Sogovri, Land Council for the appearing for the petitioner has submitted that. Has submitted that the brief of the case is not presently available with him, and he has sought for listing of the case after the ensuing long vacation. It is submitted that consent will be taken from the Land Council for the respondents. The paralegal is the case after the ensuing long vacation on a date to the expedite office.
Please, your lordship. Lordship, in item number 13, we have filed an affidavit in opposition against an IA.
13.
13, lordship, supplementary list.
Hmm.
We filed an affidavit in opposition yesterday, your lordship. Lordship, may kindly be pleased to call for the same, lordship. Lordship, I have another prayer, lordship. I'm praying for listing of the arbitration petition, if lordship recalls, lordship, regarding the constitution bench arbitration. Lordship, we have found some high court judgments which have come subsequent to the reference order, which goes in our favor, lordship. So, lordship, I pray for listing of the matter. before-
But that railway judgment is still waited.
Still awaited, lordship, but you find some high court judgments.
No, brother. In view of Supreme Court judgment, you cannot rely on High Court judgment.
No.
May I please, your lordship. Lordship, I'm praying for similar matter, lordship, relating to non-payment of contractors' bill, lordship.
Non-payment of
Contractors' bill, lordship.
next week.
Item number 1 for admission.
May I please, lordship? Lordship, AFDC on last week filed an affidavit in opposition. We have to file a reply against the affidavit in
We
opposition.
are interim is operating, Lord.
My lord.
You have filed affidavit.
On last
Sharma?
day, they have.
Yes, we have filed that.
Yes, Mr. Ali.
My lord, the whole question is that, my lord, when this single bench order a settlement in as per direction of this Sonal Court of the private respondent settlement was set aside.
Right, but at least the right to file some
My
reply,
lord,
right to file some reply
yes,
is
my
there.
lord, that is right, my lord, but they filed their affidavit, my lord, private respondent, my lord. on
21-9.
29, my lord. But as per my information,
Then this will go after vacation then.
my lord, and nobody was
Oh, why?
operating the fishery, my lord.
Lordship,
That's okay.
before vacation is possible, Lordship.
Not possible. This cannot be on at your discretion.
My lord, my humble submission, my lord,
No.
in
It will go after vacation. H. Ali. Last week cannot be. Last week will be declared as motion raised. H. Ali for the petitioner. Who is for the state? Zibo Kolial, Vihidi Bhagwat, Mr. P. Sharma, A.D. Chaudhary. Mr. A.D. Chaudhary, Land Council for the respondent number 7 has submitted that the respondent number 7 needs to controvert certain amendments made in the affidavit filed on behalf of The respond number 1,327. And he has paid for 10 days time to file such affidavit in reply. Full stop. It will be filed on 21/9/2023, affidavit filed by 1,327. The praise the Lord, leads back is after the ensuing long petition on a date
My lord,
by the office.
my lord, kindly date may be.
Interim order is,
My lord, there is no interim order, my lord.
nobody is
order-
nobody is operating.
Yes, my lord. That is the, my lord, we have
We fixed it, Mr. Ali. Now they have come up with that prayer.
date only, my only date.
After the vacation, we do not fix after that.
Item number 4.
Meet with the lordships. Others are appearing item numbers 2 and 4, my lords, in this series, my lords. I am led by senior counsel Mr. I. Chaudhary. He is in the midst of a hearing, my lords, in court number 2. May I pray that this matter may be taken after the vacations, my lord. There is no such urgency. They are running the proceeding.
Who is for the other petitioners?
Miss D. Buda kahan hai?
Mr. S. Vishwakarma, learned counsel. For the petitioner in 2
2 and 4, my lords.
and 4. Has paid for listing of the cases after the ensuing long vacation. Mr. Who is there? For state. M. G. Bokulia. Learned junior government advocate Assam for the state respondents, and Mr. N.C. Das, learned senior counsel assisted by M.S. M. Bora. Learned counsel for the respondent society. In all the 3 petitions are present and have agreed to the prayer made by Mr. Vishwakarma. First of the learned counsel for a petitioner in 3 is found absent today on call. First of list the cases, all the 3 petitions immediately after the ensuing long vacation on a date to be fixed by the office.
Obliged, my lords.
Any interim order?
No, there is no.
Item number 5.
It is a matter, in spite of the stay order given by the FCI, they passed an order pertaining to recovery from me. That order was stayed and May 2022. However, by that time already recovery was made and money was withheld, my lord. There is some urgency and pleadings FCI was taking repeated time. And last chance was given by 16A. And they filed an affidavit in reply at last, my lord. The matter is short and simple.
Other side.
You give in here, madam.
There is no one.
Let me start for a while, then I'll wait, my lord.
Okay, we'll wait for some time.
Hmm.
We'll wait for some time.
All right, or I can give a nutshell of the case and then wait, my lord.
No, if they should be present,
Okay,
we'll wait for some time.
yes.
Item number 6.
My lord,
I had to deliver, but you can find another. Yes.
On last occasion, my lord, the standing counsel for the BTC
He has received the records.
records and instead of financial soundness certificate,
No,
in Plague, your lordship has.
No,
found
let us
something-
see, start from the beginning.
Yes.
NID. Okay, this is for what? So send more.
Send more, my lord.
Okay,
And comparative statement, page 32.
Okay, you are,
I am at,
what are the conditions? Let us see first and what are the documents to be submitted?
yes. Page 20. And relevant document on last.
Now, who is it upper limit?
There is no mention of upper.
Hmm?
There is no mention of upper limit. Yeah, upper limit. In fact, clause 13D.
No, but I think clause 12 has operated. Tenderer should,
Yes, all have, all this.
that is what has,
Everybody-
otherwise how can 8%?
25%.
Uh,
Everyone has,
Please take me to that.
yes.
Should be parents. Respective. What is this English within BTR as well as people of BTR area in respect to tendering in every model with bidding value after so above the fixed same was approved. Code fee. What is this page 32 declaration?
This
What
is
is
the
the
comparative statement.
no, comparative statement after
And
the code
1,
fee
3,
column?
4, 5,
What is this declaration?
7 people are equal.
No, what is the declaration column
Yes.
in the comparative statement?
That is scrutiny observation offered 25%.
No, page 32.
Yes.
After the names of the tenderer, there is a column CF, meaning thereby code fee.
Code fee.
What is the next column? Declaration.
Declaration.
It is related to which clause? Is there any clause related to that declaration?
My lord,
Do you have any idea? Because everybody is yes.
everybody is, yes.
So what is the declaration? To which clause it is related? Yes, Mr. Rava, can you throw some light?
My lord,
What is this declaration in the comparative statement? EM I could understood. I could understand what is the EM. Where is that EM? EM clause? Earnest money clause?
earnest money, my lord.
Which clause? Where is the earnest money clause?
This-
We know the advisor carefully go to the contents.
ita mo na lang.
Fifteen minutes.
15.
15.
Okay. GST is related to 13C. PAN card 13C. IT
Income tax.
FSC is 13D. Caste certificate. Caste certificate is required. Hmm?
So as to prove that he is a resident of BTR.
The caste certificate does not
Maybe.
say
Maybe for that purpose,
BTR.
just to prove.
Caste certificate may be with relation to exemption from earnest money.
Earnest.
Is that the tender form is available somewhere?
Yes, my lord.
Yes,
Tender form.
Page
Okay,
26.
tender form.
26.
Submit my tender, name of the husband, previous expense, name, description of which
Tender.
bank draft, income tax. Okay, income tax is there. Clearance certificate, soundness certificate, registration certificate. Yes, of tender, yes. 29.5, page 29. Page 29.5.
ST.
Okay, all are yes.
All are yes.
And amount offered is,
Similar.
what is the value of that mahal quoted in the tender document? 24,31,000.
Yes, madam.
So all this figure is
Above.
25% above.
Above.
30,000, 38,750. Offered, all document furnished. So serial number 5 in page 32.
Yes, madam.
His value is 5 paisa less.
Yes.
So 1, 2, 3, 4, 5, 6.
6.
6 quoted same value.
Same.
And you are also one of them.
Yes. Ajay Kumar Basumatari, serial number
Okay.
6.
Let us see your pleading. That day some submission was made as regards the way you have structured the writ petition. This is action of the similar footing. Who has filed affidavit here?
The respondent number 5.
Let us see his affidavit. Nosiram Devimari.
Yes, ma'am.
It's
Where is the provisional letter of intent? Okay. Sixteen three. When we set aside 16:3. So is there any interim order status quo?
Yes, my lord. Okay. Lordship's kind permission, what transpired on last occasion was, my lord, possibly when the record was produced, they took note of a consideration which was perhaps not genuine. Otherwise, the writ petition was filed from a different perspective.
No, I have seen.
Therefore, the
yes.
tentative view which the lordship has taken of
No,
the-
it is there. I have seen,
Yes.
though not in pinpointed,
Ah.
but this what you have pointed out,
Yes.
it is there in the writ petition.
Yes, my.
Come to page
In fact,
you
it
have
was
taken me to that
para 8, my lord,
para 8,
of the writ petition.
but the para above 8.
Ah.
I think para 9.
Ah.
Para 9.
Yes. Actually, my lord, when the record was produced by my learned friend, my lord, what transpired was they took note of those financial statements.
Of a document which was not
Not-
part of the documents which were asked for.
Therefore, Lordship, tentative view taken on the last occasion on my lord, let them decide in accordance with the.
Within
tender
the
conditions.
confines of the tender
Yes.
NIT and the tender document
Yes,
to choose the first among equals.
yes.
That is what, so that for that purpose, I am looking into the records
Yes,
and pleadings also.
yes,
So we are not displacing anybody,
yes.
but the only thing is that it has to be
Done
on a
as such.
criteria which is within the
Whatever is
confine
the
of the tender
tender,
document.
yes, within the ambit
And
of the tender.
It is left to the discretion because say financial soundness certificate was called for, so from the bank. So it may be a criteria. I am not hinting it,
Yes. If
In the-
whatever conditions prescribed in the tender,
tender,
based on.
and
which-
not outside extraneous document,
Yes,
which was never called for.
yes.
Show me the records.
And my lord, the such criteria has to be notified at the very beginning.
Even if now, the question is that to dislodge the tender process, otherwise everything is valid. 6 persons
Equal.
have quoted equal value. Now, the criteria is to
Find out the first.
find
among
out the first
equal.
among equals.
Yes.
And that has to be confined within the documents which were asked by the tendering authority to be submitted to the tender. The parameters they will see why we do not cheat over that.
My lord, my lord.
That is what. This red mark. Okay. Okay, that certificate for 5 years, latest turnover. Where is that document? I have seen the comparative statement, that document.
Flag A probably.
Yes,
Last edition flag. A.
that the last location, it
Flag.
was placed. That income tax from chartered accountant.
Annual turnover.
Something by the chartered accountant, which was taken note of by the.
And which requirement are not in the.
187 74 112. Okay, we'll proceed on that basis. Anything?
Hang by no, concerning officer.
Anything further?
No, my lord.
We'll pass the order in the writ petition.
My lord.
The instant writ petition under Article 226 of the Constitution of India is preferred to a sale. A communication bearing number is 33, dated 16/3/2023. Entirely. Of the respondent number 2. Address to the respondent number 4. Post by the impin communication dated 16/3/2023, comma. The respondent number.
My lord, another aspect, I think we must inform your lordship, my lord. From the RTI reply, we got to know, other than the petitioner and our client, others have withdrawn their honest money. So therefore, essentially, it will be a consideration between the petitioner and our client.
Okay, we can say interested
Yes.
bidders. By the seat impin communication dated 16/3/2023, comma, the respondent number 2 had conveyed that the Oroland Territorial Council BTC had approved the comparative statement to settle the Rota Bagan S. Pustak Mahal under Thonsiri Forest Division, Udalguri, for granting the mining contract in favor of the respondent number 5, terming the respondent number 5 as the successful bidder in the competitive bidding process initiated by a tender notice dated 5/12/2022. To stop. The respondent number 2 had thereby requested the respondent number 3 to take necessary 4 to take necessary steps to settle the Mahal, Rota Bagan SS Mahal from his end as per the provisions of the Assam Minor Mineral Concession Rules 2013. Full stop. Whereas, to appreciate the nature of controversy raised through this petition, it is relevant to exposit the background facts, relevant background facts. Full stop. By a tender notice dated 5/12/2022, the respondent BTC invited bids for granting contract for stone sand gravel on tender sale basis on the terms and conditions set forth therein. To stop. One of the sand mahals sought to be settled by the tender notice dated 5/12/2022 is Rota Bagan SS Mahal. To stop. As per Schedule A to the tender notice, the government will be fixed for Rota Bagan SS Mahal, within bracket the sand mahal for short, was rupees 24,31,000. Full stop. The Schedule A had further mentioned that the stipulated quantity of sand and stone, the sand and stone mahal to be the permitted stipulated quantity of sand and stone which can be collected from the sand and stone mahal are 6,500 cubic meter and 6,500 cubic meter per year. Full stop. It transfers that 8 number. 11 number of bidders. By responding to the tender notice dated 5/12/2022, submitted their bids for the sand and stone mahal, quoting bid values and submitting the documents, asked for by the tender notice dated 5/12/2022. Full stop. The bid evaluation committee had scrutinized the tenders along with the documents submitted therewith, all the participant bidders, and after scrutiny of those documents, had prepared a comparative statement in order to settle the sand and stone mahal in favor of the success, in favor of a successful bidder. For ready reference, and the relevant extracts of the comparative statement, which is made part of the writ petition as an excerpt 4, are extracted herein below page 32. After the written, comparative statement. The respondent number 4. The BTC, the competent authority in the BTC approved the said comparative statement and thereafter, accorded approval for granting the mining contract for the sand and stone mahal in favor of the respondent number 6 by terming him as the successful bidder to be settled with the sand and sand mahal. Full stop. Assailing such approval of granting the minor contract in favor of the respondent number 6 by the communication dated 16/3/2023, the instant writ petition has been preferred. I have heard Mr. Idhor, direct counsel for the petition. Mr. Yasarabha, you represent also one? Mr. Yasarabha, standing counsel, BTC, for the respondent number 1 to 4, and Mr. Ken Choudhury, senior counsel, assisted by Mr. A. Das, direct counsel for the respondent number 5. Full stop. It is Mr. Idhor has, when counsel for the petition has contended that out of the 11 participant bidders, how many? 6. 6 had quoted same bid value, the same bid value of rupees 30 lakh, 38,750. Full stop. The bid evaluation committee had found all those 6 bidders submitting all the required documents and accordingly, term the bids of all those 6 bidders as regular in the comparative statement. Full stop. It is the respondents authorities had however preferred the respondent number 6 as the successful bidder without indicating as to why he could be termed as the first among the 6 equally placed bidders. Full stop. Mr. Choudhury and its senior counsel for the respondent number 7 has submitted that
Respondent number 5.
person
Respondent number 5.
pursuant to the communication dated 16/3/2000. The communication dated okay, then this was preceded by this piece annexer 1 or Mr. Das in your affidavit, right?
Yes.
The submitted that the communication, impugned communication dated 16/3/2003 was issued pursuant to approval to the comparative statement prepared for the Sand and Stone Mahal for granting the mining contract in favor of the respondent number 6 by the respondent BTC authority by communication bearing number so and so dated 15/3/2023 issued under the hand of the secretary BTC, page 59, running page. Full stop. Pursuant to such approval, a provisional letter of intent LOI was issued in favor of the respondent number 6 on 17/3/2023. Full stop. The respondent number 4 had also on 17/3/2023 forwarded, requested the Director of Geology and Mining Assam to prepare a mining plan in connection with the mining concession area of Rota Bagan Sand and Stone Mahal. Full stop. The Director of Geology and Mining Assam had thereafter accorded its approval to the mining plan submitted for the Sand and Stone Mahal on 28/3/2023. Any agreement was signed also?
Yes.
So, after completion of all such required formalities, a contract agreement was also executed for the mining contract area of Rota Bagan Sand and Stone Mahal on
6th of June 2020.
6
Yes, Your Honor. At page
36 or 66
6th of June, 6,
6
page
2020
94 of the IA law.
6 2020 Pusto. As the process of granting the mining contract in respect of Rota Bagan Sen and Senmol had progressed to such an extent, comma, it is not and there is no need to interfere in the matter as no public interest has suffered in view of grant of the mining contract in favor of the respondent number 6. Our inference is called for at this stage. Post. Para. As our Mr. Raval, understanding of BTC. The no BTC authority, the respondent authorities have not filed any counter affidavit in the petition, comma, Mr. Rava, understanding also BTC has produced a relevant records of settlement. Post. Para. The tender notice dated 5/12/2020 had mentioned that clause 5 clause 5 to put credible. Full stop. Clause 12 of the tender notice had provided that the tenderers how it is to be English is languages preferences would be given to those tenderers who are residents. Local word is not use of local people is not good.
Even to.
Who are residents or inhabitants?
They have
Which one is
written
proper?
Local people in residence.
Residence isn't the word, Malu, antithesis to the constitution. So inhabitants will be.
Inhabitants.
Inhabitants.
Who are inhabitants of the areas within the Bodoland Territorial Region, BTR, which bidding value, with bid value up to 25% above the government fixed value. Government value fixed in the tender notice. Full stop. Clause 12 had indicated that the approval was granted for such preferences. Full stop. Subject. Clause 13 of the tender notice had specified that a bidder, a bid had to be accompanied with the following documents. Clause 13 is 21. C to C. It was indicated in the tender form, which was to be affixed to its court fees terms worth rupees 8.25, that income tax clearance certificate had to be annexed with the bid. Full stop. It further stipulated that in case the bidder belongs to ST/SC/ OBC, the original or certified copy in support of his claim to have a claim that he belongs to such community from the scheduled caste SC/ST/OBC was to be submitted from the deputy commissioner or subdivisional officer. With the above conditions, when taking into account the above conditions set forth in the tender notice and the tender form, the comparative statement are looked at, our comparative statement is examined. It is found that 6 of the 11 participant bidders, including the petitioner and the respondent number 5, had the bid evaluation committee looked at, examined, it is noticed that the bid evaluation committee had found six of the 11 participant bidders, including the so and so and so and so, to be complying with the aforementioned terms and conditions on the premise that they had submitted the requisite court fee, declaration, earnest money, GST certificate, PAN card, income tax clearance certificate, financial sound certificate, and the caste certificate. Which such the bid evaluation committee had declared that the 6 participant bidders had furnished in the remarks column. The bid evaluation committee had mentioned that all documents were furnished by those 6 participant bidders, and accordingly their bids were turned regular. Full stop. Thus, a scenario had emerged before the responding authorities that 6 of the bidders were found having quoted the same bid below rupees 38,750. were on somewhat similarly, or were more or less similarly situated. Full stop. Mr. Rava. Well, standing of BTC has submitted that such quotation of similar value, bid value by 6 bidders could be related to clause 12 of the tender notice, wherein it was indicated that preference should be accorded to those bidders who are in evidence of BTR area and who had quoted bid value up to 25% above the government fixed value, i.e. rupees 24,31,000. Full stop. Well, it is when in the above the region or to find out the region as to why the respondent number 5 had been chosen as the first among the equals, comma, understanding of the BTC has submitted that the region for preferring the respondent number 5 as the successful bidder can be found out in the remarks made by the bid evaluation committee after preparation of the comparative statement, wherein 6 of the 11 participant bidders were found regular, quoting the same bid value of rupees 30,000. Full stop. In the note below the comparative statement, comma, the bid evaluation committee had reported that the respondent number 5 had submitted a turnover certificate for 5 years, and the the bid evaluation committee had further reported that as per the turnover of the last financial year, comma, that is, comma, 2021-2022, comma, the annual turnover of the respondent number 5 was rupees 1,87,74,112. The bid evaluation committee had further remarked that the other 9 number of bidders had not submitted the annual turnover certificate. Full stop. Where is the BTC approval? $15,300.
Yeah.
15P, you will find it page 59 of the affidavit in application.
I have seen your annexer. I want to see from the document. Your annexer A is the approval.
Yes.
Conveying the approval. Annexer A 59, right? Now, where is the approval? To say that BTC is pleased to approve the comparative statement. See. Marvin, Marvin. Okay. It was on it transpires that when the matter was placed before the competent authority in the BTC, for according approval to the comparative statement prepared for the Sen and Stone Mohol, Lotabangan Sen and State Mohol, Sen and Stone Mohol. With the above remarks of the bid evaluation committee, the competent authority in the BTC had accorded approval to the comparative statement with the further approval to grant the mining contract to the respondent number 5. The records of settlement produced by the learned Standing House BTC contains the document or as regards the financial turnover, annual turnover of the respondent number 5, on the basis of which the bid evaluation committee had proceeded to term the respondent number 5 as the first among the 6 equally placed bidders. First of the document as regards financial turnover is a document issued by the chartered accountants of the respondent number 5, indicating the annual turnover within bracket in rupees of the respondent number 5 during the 5 financial years, FY 2017-18, FY 2018-19, FY 2019-20, FY 2020-2021, and FY 21-2021. Dated 22/11/2022. How can it be? What was the last date?
May I just,
When was the last date?
last date was
Okay. Post.
My lord, may I just point out one thing in this regard regarding the annual turnover? If your lordship kindly peruse the documents submitted by the respondent number 5 regarding the income tax returns for the years, which I have got through RTI. These are probably there. All these incomes are zero.
Hmm?
All the incomes for the assessment year 22, 23, 21, 22, 20, 21, the total income is zero. I have a copy that I got,
Whether it is part of the tender document.
probably he has submitted. He has submitted along with the tender. His total income for the last 4 years is zero. I don't know whether the
I don't know, maybe for, because he belongs to the ST.
perhaps.
Maybe, I don't know. Mr. Chaudhary can throw light.
No, my lord. No, my lord, question is,
Just for my understanding, not, I am not putting it in the
no,
order.
issue is like this, my lord. If the income falls in the taxation bracket, then only that a person becomes liable to pay tax. Otherwise not.
No, suppose he belongs to, suppose ST.
No, ST, I don't.
There is
think
no
they-
relaxation
no,
for
in
ST.
Assam, there is none. Come on, Mike.
So his tax he's paid tax 2,48,810.
That
But
way-
all other figures are zero. I don't know for what reason. We are not making, without knowing anything, we do not make.
Decided by
But that
the-
is not even a. that
We
is
don't
not-
know, no, I am not making any comments.
yes.
Just for my understanding, I have asked you because you are conversant with income tax laws. But I have seen that only every figure is zero except taxes paid.
No, my lord, I think the balance sheet will reveal this. This is only the first page.
No, otherwise you are not making any
here-
comments.
If we go by page 117, my lord, of the affidavit, when he has paid tax of 2,48,000 and odd, then his income must be, my lord, above the limit.
Maybe, no, we are not making any comment on
And
it.
this page, my lord, this page normally does not include anything. It only includes what is the net income and what is the tax payable. If he has paid TDS, then tax paid. That's all.
You know, it is already there.
This is the form, my lord.
Hmm.
আমাকে দিয়ে এখানে দিয়ে he tax pay করেছে তাহলে তার ইনকাম উপর আছে 10 লাখের উপর আছে এদিকে তো 10 লাখ
When such statement of annual turnover considered of the respondent number 5 is taken into consideration by the bid evaluation committee to term him as the successful bidder, is considered qua the documents, certificates, etc. set forth in the tender notice dated 5/12/2022 and the tender form, it clearly appears that such kind of statement on financial turnover of a bidder was not called for by the tendering authority stroke BTC. Full stop. The tendering authority had, however, proceeded to take such statement of final turnover of the respondent number 5 to turn him as the successful bidder among 6 participant bidders whose bid value was same as the respondent number 5 and whose bids were also found regular. Full stop. Since such kind of it is well settled. That
My lord, I'm sorry, my lord, and another matter has been called.
that the bidders participating in a tender process have no other right except the right to equality and fair treatment in the matter of evaluation of competitive bids offered by interested persons in response to notice inviting tenders in a transparent manner and free from hidden agenda. The bidders participating in a tender process cannot insist that their tenders should be accepted simply because a given tender is the highest or lowest, depending upon whether the contract is for sale of public property or for execution of works on behalf of the government. All that participating bidders are entitled to is a fair, equal, and non-discriminatory treatment in the matter of evaluation of the tenders. It is also well settled that the award of a contract is essentially a commercial transaction, which must be determined on the basis of consideration that are relevant to such commercial decision. In a matter of award of contract, the state or its agencies to instrumentalities have to act reasonably and fairly at all points of time. To that extent, a bidder has an enforceable right in the court, which is competent to examine whether the aggrieved party has been treated unfairly or discriminated against to the detriment of public interest. Mahabinda Express Carrier and another, Northeast Frontier Railway and another. Reference reported in 2014-3 SCC 760. When? keeping the above principles in mind, this court has found that the bid tendering authority stroke bid evaluation committee in a matter of granting the mining contract in favor of the respondent number 5 had proceeded to take a document into consideration, a document which was never asked for either by the tender notice or by the tender form, for consideration as regards responsiveness or otherwise of the bid and to stop. The bid evaluation committee is remarked that in the comparative statement, which has ultimately affected the decision-making process, that the other, perhaps 11 নহয় দেই 10 হ'ব নেকি
10 between.
1 2 3 4
10,
5
10.
6 7 10 11 নহয় 10 other 9 bidders had not submitted the statement of annual turnover certificate is found to be irrelevant as such statement on annual turnover was never asked for at any point of time by the tendering authority, either by the tender notice or in the tender form or by any communication subsequent to the bid submission date. In such view of the matter, this court is of the unhesitant view that the decision-making process leading to the approval, the bid evaluation committee, the tendering authorities, bid evaluation committee, was found to have guided was found to have taken an irrelevant factor by taking a statement, taking a document like the statement of annual turnover certificate of the respondent 5 into consideration by taking the as the tendering authority stroke bid evaluation committee ought to have confined itself in the decision-making process ought to have confined itself to the within the confines, to have confined itself within the terms and conditions set forth in the tender document and the tender form Full stop. In such view of the matter, comma, this court is of a considered view that the decision-making process leading to the decision of granting approval to the bid of the respondent of 5 as the successful one is found to have brought with infirmities as in the process, comma, the other 5 participant bidders whom the bid evaluation committee stroke tendering authority were found on equal footing are shown in are treated, are found to have been treated in a discriminatory manner as with a host of their bids were not considered to be successful on the ground that the other equally best participant bidders did not and not submitted the statement on financial turnover, comma, a statement which was never called for from them. In such view of the matter, comma, in view of the discussion made above and regions assigned therein, comma, this court has found that the decision-making process leading to the decision of according approval to the bid of the respondent of 5 is liable to be interfered with. Full stop. Accordingly, comma, the approval granted by the tendering authorities to responding BTC authorities to the bid of the respondent of 5 as the successful one is set aside and passed, full stop, with the setting aside and passing of the approval. Comma, the matter stands remanded to the respondent BTC authorities to proceed with the matter afresh for granting approval to a successful bidder on the basis of from the stage of preparation of the comparative statement and by taking into consideration the relevant factors which are set forth, relevant factors and the terms and conditions set forth in the tender notice dated so and so and the tender form and the documents submitted by the participant bidders. It is relevant to point out that such exercise shall be undertaken by the respondent BTC authorities or tendering authority or by taking the bids of those participant bidders who are still in the fray.
My lord.
That will do.
Yes.
With the observation made and direction given above, the writ petition is allowed to the extent indicated above. There shall, however, be no order as to cost. Some correction, give me one day. Within a period of 1 month.
I
Huh?
think that
Mr. Rabha, Learned Counsel for the Learned Standing Council BTC has submitted that a period of 1 month would be a reasonable period for the respondent BTC authorities to undertake and complete such exercise. Last for liquidity.
the earlier interim order stands merged with this.
The earlier interim order stands merged with this order.
Obliged.
Going to file?
Item number 5.
My lord, as I said, my
I
lord,
see,
submitted.
at first, my sincere apology, my lord, not being on time today, my lord, because of traffic jam.
My lord,
Yes,
Matter is.
kilometer,
Kilometer, my lord.
kilometer.
It was
My lord,
definitely-
Lordship, may I kindly have a look at the NIT first. Matter is very short, which is at page, my lord, 24 of the writ petition.
24.
24, my lord.
Is there already decisions on this aspect?
Yes, my lord, in fact, in one of the
Not
matters, your
exactly
lordship,
on this line, my lord.
in one of the matters, let me, I
Yes,
think I
yes.
am the petitioner, okay?
Where is the 13 kilometer?
Have a look at page 24,
24, which place?
page 24. My lord, the letters are very small, it is
Yes.
strenuous to your lordship. My lord, have a, it's a contract for 6 months. The box, in the box, my lord, top security deposit and all these things are. I'm sorry, my lord, lordship, the relevant will be page 25. Page 25, please, may come to page 25.
25.
Yes,
Okay.
handling and transportation, so and so contract. My lord, name of the work, lordship kindly see. Handling and transportation contract at X railway siding, North Lakhimpur, including transport contract from X railway siding, North Lakhimpur to FSD, North Lakhimpur, within bracket,
Okay.
distance 13 kilometer.
Okay.
This is important, my. And reason on. And security deposits, my lord, right hand side column, my lord, security deposit. Below.
So there is no dispute on that.
Yes, on that basis, my lord, we
Okay.
submitted our bid and we were appointed by order dated 19/6/2015 at page 27. Page 27.
27, allotment of
Yes.
handling and transport contractor.
My lord,
Yes,
the appointment order, it says at page 28 that 219% above schedule of rate for transportation and 230 above schedule for handling. Then I commenced the work, my lord, and I completed the works within 6 months without any blemish.
So basically, this appointment letter becomes the concluded contract.
It is 13
There is
kilometers.
no separate.
No, it is 13 kilometer. Therefore, my lord, I submitted my tender. Had it been written that it is something less, I would have quoted different rate. Obviously. Now, my lord, I completed the works in June 2016.
June.
Unblemished. But for my lord, 4.5 years thereafter, FCI didn't pay me the bill.
June 2016.
16.
Where is the
From
statement?
June, I'm sorry,
Where is the
started December 2016, the work was finished.
Where is the statement?
My lord, as per the order itself, page 27, it is written, my lord, 6 months. 3 months, they extended, my lord. And the tender notice also, it is stated that it is a 6-monthly contract. 6 months.
Annexure
contract
1,
is
Annexure
for 6
2.
months.
No, any statement so that
No, my lord, it is reflected, my
petition
lord.
is executed work
24.
in that.
Page 24. The bid was invited for contract
Right, no.
ad hoc basis for 6 months.
Mm.
So now my appointment order was on, my lord, 6 months. Now my appointment order was 19/6. Therefore, the work was completed by 18 December, 6 months. It is obvious. It is obvious. So,
Come to paragraph 5.
yes, lordship. Yes, that is petitioner.
So
yes,
this is your bill amount,
Yes,
56 lakh 11,000
Yes, yes.
653.
My lord.
Ah,
Then when I was not paid my bills,
48
I-
lakh 5
Ah.
50,000.
I'll come to the amount, my lord, exact amount.
Paragraph 5.
I will show my lord from their affidavit also. I submitted my lord representation that then out of 56 lakhs, a part payment was ultimately made of 48 lakhs,
Hmm.
excluding the security deposit and earnest money, and plus the security deposit and earnest money amounting to 2.5 lakhs. This is admitted. Now, after 6 years of completion of my works, FCI issues a recovery notice at page, my lord,
Hmm.
31. This is the impugn order notice and followed by the order. Lordship, may I have a look? 19/4/22, December 16, I completed the work after 6 long years of completion is stated. Where is your appointed? Issued regional office. Now it is to inform that a letter number so and so revision slab dated 25/2/2020 to copy enclosed has been received from AGM contract regarding recovery of an amount which was paid to you as an extra amount for taking a longer distance route of 13 kilometer instead of 8 kilometer for transportation. As per observation made by special audit team. In view of above, it is directed, I am directed, my lord, directed to deposit an amount of 12 lakhs and account of FCI so and so, and below, otherwise the same will be recovered from your bills. Now there are few things. This letter was never communicated to me. It was their internal communication 25/2/2000. And my lord, it clearly mentioned 13 kilometer, as I said, my lord. Had it mentioned, my lord, 8 kilometer, I would have put it at different state. 6 years after completion of the work, my lord, they discovered that it is not 13 kilometer, but it is 8 kilometer. So who is accountable and responsible for that? The man who floated the tender, the general manager. General manager. And my lord, moreover, no notice to me before this unilateral impugn order. That is also, also may make note of. There's a suddenly gives this. No notice to me. And you are not supposed to make a rediscovery also. So, and law is settled, my lord, Ramanna Dayaram is known to your lordships, that when the authority professes something to the public, they must adhere to it. These, my lord, declarations, and they cannot make a somersault subsequently. That is well settled, my lord.
What
Ramanna
is their stand in the affidavit?
My lord, now, next page, my lord, kindly next page 32. It is to the divisional manager. It is again their internal communication.
Which one?
Page 32, 25
Okay.
to 20.
Then by which you are asked to deposit?
Page 32. It is a follow-up to the earlier notice, my lord, I have shown.
It is addressed to you. It is also not addressed to you.
It is also not addressed to me, neither a copy has been given to me below, my lord. It was internal correspondence between the assistant general manager and the divisional manager.
How you have come to know?
Lordship,
How you have come to know?
my lord, I have come to know after when they didn't give it. When they didn't give it, this notice was given to me, my lord. This notice was given to me. NIT Traders, page 31.
Is 31.
Below. Sewa May, NIT Traders.
Okay. 19/4.
19/4 was given to me. Then I got, my lord, this one. I don't know. This is not a privileged document. I got it. So
Basically 19/4,
19.
2022, that was a notice served on you.
yes.
That you have been directed to deposit this much of amount
And by this, my lord,
on the ground that longer distance
longer.
instead of so
And by this internal correspondence, the my lord divisional manager was directed to take necessary action for recovery of 12 lakh and odd. Now, my lord,
Divisional manager, 1 minute.
Yes.
32.
yes. So,
Expired.
so actually, this amount, this notice was stayed and recovery. When I approached, my lord, at the motion stage
Expired.
35/2022, my lord, the impugn order was 19/4/22 was paid. But in spite of that, they kept certain amount with them and released only a part of it, my lord. I could have filed a contempt for that, my lord, but somehow didn't, I'm not interested in that. Lordship may kindly have a look at the affidavit at page. FCI's affidavit at page. Oh, and I guess we should put that might. Page 40, my lord, running page, I think. Yeah, hold on. 40 running page, my lord. Affidavit dated 15/9/23.
40. Okay.
Paragraph 11. Paragraph 11, roundabout in the middle, my lord. The said fact was that it is not 18 and it is 8 kilometer. The said fact was detected in the special audit conducted by FCI John, wherein it has been stated that while
Which line
verifying-
you are reading?
My lord, middle, my lord, middle. Paragraph
Middle.
11.
Ah. Yes.
This said fact was detected that the distance is not 13 and 8. It should have been 8. In the special audit conducted by FCI, wherein it has been stated that while verifying the concerned file, inconsistency in distance measurement between 2 points in 2 successive ST contacts was observed. In the said audit report, it was also observed that before the issuance of appointment order, an email dated so-and-so was received from divisional office. It is also internal email, not me. When they have revised the distance from railway, they have revised. However, without considering the revised distance of 8 kilometers, the contract was awarded.
So did they initiate any disciplinary proceeding against the person?
There should have been against the manager contract. And my
Is
lord,
there anything?
and lastly, my lord,
They takes, my lord. They takes.
No, is there anything in the statement? We do not want what had happened inside your department, whether you have made any statement that some disciplinary proceeding was also taken. If you are making this statement, email dated 29/5/2015. So hiring officials should be proceeded with. There is nothing.
They takes, my
No,
lord.
they, we don't go by that. They normally take. Yes.
my lord, look at the attitude of FCI, my lord, paragraph 8, page 37.
37.
In spite of the, my lord, interim order, staying the notice and the order of recovery.
37.
Yes, same, my lord.
Okay, which paragraph?
Paragraph 8, page 37 of the, my lord, FCI affidavit. As you also got it. That the state is so and so, so and so, so and so, not true, not so. I say that the petitioner was initially paid an amount to the tune of 50 lakhs and an amount 6 lakhs or 1,000 was kept pending. As the said amount of work was done beyond the delegation of power by, that is their business, my lord. As the divisional manager can only allot. The higher authorities are also party respondents here. So admittedly, they have said that an amount of 6 odd lakhs kept pending. And obviously the add to that, my lord, the security and the bank guarantee, etc. So that is precisely my case, my lord.
Hey, please, as you are.
In page 27, is it mentioned somewhere 13 kilometer? Page 27. What is ASOR?
Above schedule of rates.
Schedule of rates.
Above schedule. The base rates are very old, my lord.
In the NIT, it is written, my lord, 13 kilometer at page 25. That's first, second column.
So basically this appointment letter is the contract.
Yes.
And there is a MTF model tender form that the party has to sign. That governs the tender. Now, my lord, I will come to paragraph 8 of my affidavit in opposition. That is at page 37 running page. My lord, since it was an ad hoc.
So far as if the original appointment order is given effect to, then an amount of 6,11,491 is
Pending.
pending if the original appointment order.
Yes, ma'am.
If the notice is given effect to, then you want to recover 12 lakhs
12 lakhs,
something.
12 lakhs and odd.
The meaning thereby, so this will be not paid. This 6,11,000.
No, my lord, why this was kept pending, because I'm coming to this point, my lord. Again, will come to paragraph 8. My lord, since this was an ad hoc contract which is floated floated on the DOP, that is delegation of power of the general manager, floated by the North Lakhimpur district office, my lord. The
How
power-
did how did
power is
you
my lord,
realize?
50 lakhs, my lord. So when the
No, how did you realize all these things after 6 years?
That was while this 6 lakhs was being examined and being waiting for the approval from the regional office, my lord. The special audit meanwhile conducted, and it was found that it was not 13 kilometer, but it was 8 kilometer, my lord. That's relevant part of the audit report is at page 46, my lord. Page 46 of my affidavit in opinion.
Basically, you are changing the term of the contract.
Well, because it came to light later on that it was not exactly. 8
So
kilometer.
without
The
consent,
grievance of the petitioner is that only rate, my lord. That
okay,
is-
is it a statutory contract?
Petitioner is not denying, my lord, that it was
No.
8 kilometer.
That is not the question. Is it a statutory contract?
It is a statutory.
No.
contract.
Absolutely not. How can you say? On what basis you are saying?
Statutory contract, my
Do you know what is statutory contract?
statutory contract by meaning, my lord, that FCI has plotted the tender.
Just because you are an instrumentality of the state
Yes, ma'am.
does not make the contract a statutory one.
I'm getting it, my.
You are getting it.
Yeah.
So this contract is to be governed by the ordinary laws of the contract. It falls in the realm of private law. So if you want to change a term of the contract, consent is required to be taken. Yes, we have done some mistake. 13th kilometer, it should be 8. It should be during the operation of the contract,
My lord,
right? Then if he does not agree, then you terminate the contract. There is no offer and no acceptance.
that-
But here, contract has been walked out to its fullest. Thereafter, 6 years, you have realized something has happened. Why should we permit you?
So, my lord, the notice was issued to him.
Come to the laws of the contract. Address on that point. The contract agreement, which is of to be governed by ordinary laws of the contract, that is Indian Contract Act, has already been worked out. He proceeded on the basis of your appointment order, submitted bills to the tune of so much. You have given him 50 lakh. Now, when 6 lakh he was demanding, you have come up with this plea. That too after 6 years.
My lord, my only humble submission is that the notice was issued on 19/4/2022 to the petitioner that look here. this
That is not notice, that is direct order.
So
No
without
so cause.
ventilating his grievance before the
No
in-house mechanism, my
so-called.
lord. Grievance
No,
redressal
you are
center-
directed. Come to page 31.
Yes, I have seen, my lord.
You have
I agree
directed,
about
it
it
is not a
directed to the
so-cause notice.
The so-called notice it ought to have been there, my lord.
So
Before-
no
before
opportunity
that-
also.
Before that, my lord, on 25/2/2022, the inquiry was made.
That
by
is
the-
internal.
That was inquiry was made and it was found that it was not 13 kilometer, but 8 kilometer.
But
and
he has been
accordingly-
communicated only by page 31.
Page, yes, brother, 19/4/2022, page 40, annexure B of my affidavit in office.
Anything more?
Now, one main contention is that the petitioner is not denying that it was 8 kilometer.
That is not the
Only
question.
contention of the petitioner is
That is not,
my rate
no,
was
that
13
is not the
kilometers.
question. You have arrived at the decision without,
It is
without giving him any opportunity also.
That is true. There
This
was
is
no-
not sustainable also. If he is likely to be affected,
So, my
then
lord-
there ought to have been prior notice.
So, my lord, my humble submission is that let
No, contract has been worked
let-
out.
Let him give a representation and the.
No, this is
authority
not,
will
this,
take a
this is
decision
not
within 30
sustainable.
days, my lord.
This notice is not sustainable because you have arrived at the final view.
Notice maybe, this
We can
notice
put-
may be set aside and plus a representation he may make with this.
Why
regard,
should
my
he
lord.
make a representation? He doesn't know anything. If this is set aside, he doesn't know anything.
Opportunity may be given to the FCI to make to give a saw cause, my lord, before coming to any.
No, everything has been worked out, mister, and it is not a case of
My humble
novation of,
submission is made that to
See,
that effect, my lord. and
that is why I have
opportunity
put the
given
question.
FCI, my lord.
that is why I have put the question.
I
This
agree,
is,
my
this
lord, that
is
this is
to
not
be
a
governed by ordinary laws of the contract. If something is to be changed, that has to be changed with the
Yes.
consent of the,
opportunity
other
has to be
party.
given, my lord.
and if he does not agree to it, then you terminate the contract. But after the contract
was
is
completed.
worked out, now you cannot make another condition that, no, it should be 8 kilometer, not 13. Maybe by mistake. I'm not found anything.
Yes, my lord. I do agree, my lord, that FCI may issue a saw cause notice.
There are other decisions also by this court, is it not? Tell me.
That decision.
You
will
are an
fa-
officer of the court, tell me.
That decision will favor me, my lord, because in other
Now,
cases
show me.
where,
Which decision will favor you?
because on all these cases, the NIT has shown lesser kilometer, it was found to be more kilometer. So this court has given that, no, you have to give the rate as per the actual distance, my lord. So here it is, the actual distance will be 8 kilometer, my lord.
My lord, in similar matter, it was set aside and directed.
It does it. Tomorrow.
There also they had concluded work. 3-4 years thereafter, my lord, they
Hmm.
discovered the distance. It is FCI.
So,
Which paragraph?
Here, lordship.
Yes, Mr. Singh, anything more?
there was a division bench decision, my lord, where the court has given an finding that the writ court will not go into the matter and recalculate the rate, my lord.
We are not calculating it.
And where, because why?
We are taking decision on the notice.
Notice that.
And more particularly when the contract itself was of 6 months and it was worked out 6 years back. And for changing the
Why
terms
it
and
is-
conditions of tender, there ought to have been novation of the contract. There should have been that I am changing this condition in the contract. Tell me whether you will accept or will not accept. If he
When the-
accepts, it will go. And if he does not accept, then it will be terminated.
And when this matter was came out, the contract was already completed, my lord. It was only of 6
So-
months, my lord.
So there was nothing.
That 6 lakhs was pending for approval, my lord, when then this special audit came into.
We'll come
binding,
back and pass the order now.
My lord.
Advocate General,
Next.
next. Probably at 2.
2 o'clock.
Can start afresh.
Yes, lord.
at 2 o'clock. We'll dictate this order.
Lordship, hello.
Who is this 31 Hindi term? Is respondent number 2.
Which page, my lord?
Page 31. Mondal Prabandhak. I don't know the English designation. English designation. Mondal Prabandhak.
Divisional manager.
Divisional
Manager.
manager.
Respondent number 4.
Yes. Divisional manager. Now district managers are called divisional managers actually.
Mondal Prabandhak.
For number 4.
Mondal Prabandhak. Issued by the respondent number 4. Whereby the petitioner has been directed to deposit an amount of rupees 12,60,298.18 in the account of the respondent FCI in the designated in the specified account of the respondent FCI on the premise that the said amount was paid to the petitioner firm in excess from the respondent FCI. Full stop. By the notice dated 19/4/2022, the petitioner has been directed to deposit the said amount within 50 days from the date of issuance of the notice, with a further observation that the petitioner firm should adhere to the contract agreement and deposit the said amount within the stipulated period. Otherwise, the said amount would be recovered from the petitioner's bills, security deposits, bank guarantee, etc. The genesis of the dispute is traceable to an ad hoc tender inquiry published on 8/5/2015, whereby published on by the regional office of FCI Guwahati, whereby tenders were invited online under 2B tendering system for appointment of handling contract handling and transport contract transport contract for the following contract work. Page 25, box atas A to A. The ad hoc contract tender inquiry had indicated that The appointment of contractor would be for transportation of food grains, sugar, allied materials on ad hoc basis for a period of 6 months. And the FCI had reserved the right of extension for another 3 months, extension of the contract period for another 3 months or till finalization of regular contract, whichever was earlier. Full stop. The response, the ad hoc contract tender inquiry, didn't get tender notice for spot. Responding to the tender notice dated 8/5/2015, the petitioner submitted its bid for the contract work PIZ X railway siding, North Lakhimpur, including transport contract from X railway siding, North Lakhimpur to food storage depot within bracket FSD, North Lakhimpur via Weybridge and handling works at railway siding, North Lakhimpur, para 3 does. Para. The finding the bid of the petitioner as a responsive one, a letter of appointment was issued on 19/6/2015 by the Regional Office, Assam Region FCI, appointing the petitioner as the handling and transport contractor. Page 27 was subject to liquidative. Subject to liquidative. Full stop. The letter of appointment had specified that the contract would come into effect with come into force with immediate effect at the quoted rate of 219%. Absolutely above schedule of rates within bracket ASOR for transportation and 230% ASOR for handling only on terms and conditions as contained in the tender agreement. Any tender agreement?
MTF model tender form. It has not been annexed.
Full stop. It was further set forth in the letter of appointment that a contract would be governed by the terms and conditions of the tender document signed between the petitioner and the respondent FCI. Full stop. Para. It is the case of the petitioner that on being appointed as such handling and transport contractor by the letter of appointment dated 19/6/2015, with such specified terms and conditions, he deposited the requisite security amount deposit amounting to rupees 1,25,000, which was 50% of the total security deposit amounting to rupees 2,50,000, along with a bank guarantee equivalent to along with a bank guarantee for an amount of rupees 5 lakh. In addition to earnest money. Page 20. Okay, requisite security deposit. Security deposit. Uh, uh, amounting to rupees 2,50,000. And a bank guarantee of rupees 5 lakh. And completed the other requisite formalities. Full stop. The petitioner, it is stated that the petitioner had commenced with the allotted work immediately and completed the same within the stipulated period without any complaint whatsoever from the end of the respondent FCA authorities. Full stop. After completion of the work, during and after completion of the work, the petitioner submitted a total of 7 number of bills, which amounted to rupees 56,11,653.29. By reckoning the distance as mentioned in the tender notice and the work or letter of appointment, that is 13 kilometers for processing and disbursal by the respondent FCA authorities. Full stop. The petitioner has stated that the petitioner was paid an amount of rupees 48,50,000 out of the final bills amount of rupees 56,11,653.29. After making the necessary deductions as per the letter of appointment, tender notice stroke letter of appointment. Full stop. As an amount of rupees 6,11,653 was not paid for a substantial period of time out of the said final bills amount was not paid for a substantial period of time, the petitioner had approached the respondent FCI authorities by way of a representation dated 24/8/2021 with a request to disburse the balance amount in an expeditious manner. Full stop. It was after such representation, after submission of such representation on 24/8/2021, the petitioner was served with the impugn notice dated 19/4/2022. Full stop. Finding the decision contained in the notice, impugnated notice dated 19/4/2022, the petitioner as arbitrary and unjust, the petitioner has approached this court by the by this writ petition for setting aside and passing of the same. Full stop. I have heard Mr. A.C. Barboral, Senior Counsel, assisted by MS. MD. M for Mumbai or Nagaon? Nagaon. ND. Learned Counsel for the petitioner and Mr. BKC. Learned Standing Counsel. FCI for all the respondents. Full stop. Fair. Mr. Barboral and Senior Counsel for the petitioner has submitted that the tender notice dated 8/5/2015 had clearly specified the distance at 13 kilometer distance via Weybridge at 13 kilometer. Full stop. It was by taking into the entire terms and conditions set forth in the tender notice, the petitioner submitted his bid quoting a specific bid value, specific rate. Full stop. The respondent FCI authorities had accepted the rate quoted by the petitioner, and it was only after acceptance of the rate, the letter of appointment dated 19/6/2015 was issued, quoting that the rate would be 219% ASOR for transportation and 230% ASOR for handling, and the inter-relationship would be governed by the terms and conditions contained in the tender agreement. Full stop. It does, it is not open for the respondent FCI authorities to make a U-turn to contend that an amount, some extra amount was paid to the petitioner on the premise that the distance to be covered under the contract agreement should have been 8 kilometers, instead of 13 kilometers. Distance to be covered for transportation of food grain. Transportation of food grain from railway siding, North Lakhimpur, to FSD, North Lakhimpur, should have been 8 kilometers, instead of 13 kilometers. So stop. The action on the part of his term, that it is thus contended that the action on the part of the responding FCI authorities to recover such amount after the contract had itself been worked out long back, is clearly arbitrary and unjust. Full stop. Para, responding to the submissions of Mr. Barbara. Such submissions of Mr. Barbara, Mr. Singh, Land Council, Land Standing Council, BTC has submitted, sorry, FCI has submitted that the final bills of the petition was processed
Paragraph
and was found, and it was found that no, and an amount of rupees 50 lakh was paid to the petitioner. Full stop. An amount of rupees 6,11,491. The bill, the final bill amount, a part of the final bill amount amounting to final bill amount amounting to rupees 6,11,491 was not processed and kept pending, as the same was found beyond the delegation of power of the authority who had issued the letter of appointment. Full stop. He has pointed out to a report submitted by a special audit team to submit that when an audit was carried out, it was found that the distance between the railway siding, North Lakhimpur, to FSD, North Lakhimpur, was in fact 8 kilometers. As the petitioner was found to have paid in excess of 8 kilometers, the decision was taken to recover the amount, excess amount paid to the petitioner on the basis of the letter of appointment stroke contract agreement where rate was calculated on the basis that the distance was 13 kilometers. I have given consideration to the submissions of the Land Council for the parties, and I've also gone through the materials based on report by the parties through their pleadings. So stop. Para. It is not in dispute that in the tender notice dated 8/5/2015, it was clearly indicated that the contract would be for handling and transport at page 25 box at X-railway siding, North Lakhimpur, including transport contract from X-railway siding, North Lakhimpur, to food storage depot within bracket FSD, North Lakhimpur, within bracket distance 13 kilometer bracket close via Weybridge and handling works at railway siding North Lakhimpur. Full stop. From the letter of appointment, it emerges that the accepted rate was 219% ASOR for transportation and 230% ASAOR for handling. The tender notice as well as the letter of appointment had set forth that the appointment of the petitioner as handling and transport contractor was on an ad hoc basis for a period of 6 months, with right reserved to the FCI for extension for another 3 months or till finalization of the regular contract, whichever was earlier. It is the petitioner's 6 months only, there is no extension. So it is not in dispute that the petitioner, the duration of the contract was for a period of 6 months, and the contract period was not extended beyond the period of 6 months. From paragraph eight of the affidavit in opposition of the respondent FCI authorities, it is discernible that the final bills amount submitted by the petitioner would be taking the distance at 13 kilometers was not in dispute. If the distance is taken to be 13 kilometers, was not in dispute. Full stop. The contention of the respondent FCI authorities is to the effect that the final bills ought to have been were required to be the final bills amount were required to be considered by taking the distance as 8 kilometers instead of 13 kilometers. And if such a calculation is made, then, the respondent FCI authorities are entitled to recover an amount of rupees 12,60,298.18 Full stop. Does in view of such contention and the claims and counter claims, what has fallen for consideration is whether the action on the part of the respondent FCI authorities seeking to recover the amount indicated in the impugned notice dated 19/4/2020 can be termed as justified or not in the backdrop of the fact situation obtaining in the case, as exposited above. Full stop. The parties have not brought, none of the parties have brought any contract agreement executed between them on record. Full stop. As the period of contract was for 6 months, it is clear that the contract agreement if any had worked out, had itself worked out long back in the after expiry of 6 months from 19/6/2015.
6 years.
After 6 months from 19/6/2015?
6 years, my lord.
No. Long back,
Along.
long back after expiry of 6 months from 19/6/2015.
December 16.
So it goes to December. Full stop. Fair enough. Hey, Korean to asani, Korean. Though it is found a Korean bullet hill. It was spiral binding at after that. Though the respondent FCI is an instrumentality of the state under Article 12 of the Constitution of India, the contract agreement, which was entered into between the parties herein, was not a statutory contract, was not in the nature of statutory contract. Full stop. Korean. Korean. 25. You are a statutory body. FCI Act is there.
Yes,
Okay.
Food Corporation.
The respondent FCI is a statutory body. Which has come into existence under the FCI Act, Food Corporation of
Food
India.
Corporation Act.
Food Corporation of India Act 1971.
It has been stated, it has been settled that a statute may expressly or impliedly confer power on a statutory body to enter into contracts in order to enable it to discharge its functions. Full stop. It has been held by the Honorable Supreme Court
I am sorry, my
in
lord. Food Corporation of India Act 1964. actually.
64. Has been settled by Honorable Supreme Court of India in Kerala State Electricity Board versus Korean E. Kalathil and others, reported in 2006 SSC 293 that disputes arising out of the terms of such contracts or alleged breaches have to be settled by the ordinary principles of law of contract. Full stop. The fact that one of the parties to the agreement is a statutory or public body does not by itself affect the principles to be applied. Full stop. The disputes about the meaning of a covenant in a contract or its enforceability have to be determined according to every act of a statutory body need not necessarily involve an exercise of statutory power. Full stop. If the contract entered between the parties is not a statutory contract, then the inter-se relationship between the parties are to be governed by the ordinary laws of contract, that is Indian Contract Act, so and so. Full stop. As to the maintainability of her petition, the Honorable Supreme Court of India in ABL International and another versus Export Credit Guarantee Corporation of India Limited and others, reported in 2004 3 SSC 553, after discussing a number of earlier precedents, has laid down the legal principles as follows. A, in an appropriate case, a writ petition as against a state or an instrumentality of a state arising out of a contractual obligation is maintainable. B, merely because some disputed questions of fact arise for consideration, the same cannot be a ground to refuse to enter in a writ petition in all cases as a matter of rule, semicolon, and C, a writ petition involving a consequential relief of monetary claim is also maintainable. Full stop. The aforesaid principles have been followed in subsequent 3 judge bench decision in State of Uttar Pradesh versus Sudhir Kumar, reported in 2020 SCC online SC 847, and Popat Venkat Rao Patil versus State of Maharashtra, reported in 2020 19 SCC 241. Full stop. reiterating the same principles, it has been observed in Unitech Limited and others versus Telangana State Industrial Infrastructure Corporation within bracket TSIIC bracket close and others reported in 2021 to scale 653 that while exercising its jurisdiction under Article 226, the court is entitled to inquire whether the action of the state or its instrumentalities is arbitrary or unfair, and in consequence, in violation of Article 14. First off, the jurisdiction under Article 226 is a valuable constitutional safeguard against an arbitrary exercise of state power or misuse of its authority. First off. The state, it has been observed that the state and its instrumentalities are not exempt from the duty to act fairly, merely because in their business dealings, they have entered into the realm of contract. Full stop. Yeah. In view of the nature of contract the parties herein had entered into, which had been worked out long back in the year 2015. It has emerged that the inter-se relationship between the parties are governed by the ordinary laws of contract. Full stop. It is well settled principle of law of contract that a party to a contract can insist for performance of only those terms and conditions, which are part of the concluded contract. Full stop. A party to a concluded contract has no right to unilaterally alter the terms and conditions of the contract, and neither of the parties has any right to add any additional terms and conditions in the contract unless both the parties agree to add or alter any such terms and conditions in the contract. First off, it is also settled that if any party adds any additional terms and conditions in the contract without the consent of the other contracting party, then such unilateral addition is not binding on the other party. First off, a party which unilaterally adds any such terms and conditions, has no right to insist on the other party to comply or abide by such additional term and condition. First off. Having regard to the fact situation obtaining in the case in hand, it is also apt to refer to the decision of the Honorable Supreme Court of India in Kumari Srilekha Vidyarthi and others versus State of UP and others, reported in 1991, 1 SSC 212, wherein it is held that even if the contract is concluded, the state cannot cast off its personality and exercise unbridled power unfettered by the requirement of Article 14 in the sphere of contractual matters and claim to be governed therein. only by private law principles applicable to private individuals to requirements of Article 40 in the sphere of contractual matters. Full stop. The personality of the state or an instrumentality of the state requiring regulation of its conduct in all spheres by requirements of Article 14, does not undergo a radical change after the making of a contract. Full stop. It has been held that the situation does not envisage or permit unfairness or unreasonableness in state actions in sphere of its activity, contrary to the professed ideals and exclusion of Article 14. An exclusion of Article 14 in contractual matters has not been accepted. Full stop. If in view of aforesaid principles of law, when in view of the aforesaid principles of law, the impugn notice dated 19/4/2012 is considered, it is found that the decision conveyed by the impugn notice was without any prior opportunity of hearing to the petitioner. Full stop. It is further found that the respondent of CI, by its decision contained in 19/4/2012, that recovery for an amount of rupees 12,60,298.18 would be made from the petitioner's bills, security deposit, bank guarantee, etc., was without was sought to be done. Has been sought to be done in an unilateral manner without any consent from the other contracting party, i.e., the petitioner, in respect of a contract which had itself worked out as far back as in the year 2015, after expiry of 6 months. 16.
And my lord, one place.
As far back as about 16 years, 6 years back, as the letter of appointment was dated 19/6/2015, was for a period of only 6 months. Full stop. The petitioner had proceeded to execute the contract work clearly in terms of the tender notice dated 8/5/2015 and the letter of appointment dated 19/6/2015, and there was no complaint whatsoever from the end of the respondent FCI authorities during the execution period of the contract. Full stop. Any in such backdrop, the action contemplated by the respondent FCA authorities to recover the amount of rupees 12 lakhs ransom by the impugned notice dated 19/4/2012 is 19/4/2022 is found to be explicit, found to be an arbitrary and unjust one. Full stop. And the same cannot be considered as sustainable in law in view of the inter se relationship between the parties as exposited above. Full stop. As the for the said region, this court finds that the impugned notice stated so and so is liable to be interfered with, and it is accordingly set aside. Is interfered with the condition that, or with the observation that the respondent FCA authorities shall not insist for deposit of the amount of rupees 2,12,60,298.18, as indicated therein from the final bills, security deposits, bank guarantee, etc. of submitted by the petition. First of all, as a corollary, it is directed that the respondent authorities shall process the final bills of the.
No, it is admitted. They have said bills have been processed, not paid. 6,11,000.
Shall process
They have
the matter of payment as regards the amount
of rupees out
6,11,000.
653.
653.
490.
Okay, and as per their
490.
491, which is stated to be pending by the respondent FCA authorities in their affidavit of opposition, within a period of 1 month from today.
60 days.
6 weeks.
And my lord,
From the date of submission of a certified copy of this order at the office of the respondent number 4.
and my lord, about security, actually, naturally, they couldn't pay the security because there is a procedure. I must submit a no demand certificate. But because of all this, I demonstrate. Production that will be-
The on submission of a certified copy by the petitioner at the office of the respondent number 4, the respondent number 4 shall inform the petitioner within 2 weeks therefrom about the requisite formalities, about the formalities, if any,
That is the formality, no demand certificate.
required to be complied with the petitioner.
Actually, mention no demand certificate. It is clear.
No, anyway, that order will do
That's what I'll do.
within a period of 6 months.
Last paragraph, another
Six.
correction is there 19/4/2020. Your lordship has dictated 12.
19/4/2022.
22.
My lord, 3 months, my lord, all this, for all this 1 month.
3
And
months.
to make the payment, my lord, another 2 months, good enough. I'm a
Okay,
business,
2 months.
within a period of
2 months.
2 months there.
2 months from the date of receipt. 12, Mr.
where objection was filed.
Okay.
We will first take up the evening.
12, Mr. Chaudhary, you were referring.
Actually, my lord, we have filed our objection, my lord. He is a
Well-
tenderer. Now, in terms of the interim order, my lord, tender has not progressed. Therefore, my lord, I don't think he is a necessary party. That is what the stand we have taken in our, my lord.
You are appearing in item 12.
13, my lord, Hemanta
13.
Karmakar. My lord,
1
our
minute.
ground of challenge.
1 minute, 1 minute.
Fine.
In 12. Okay. What about IAs?
IA, my lord, I think my friend has filed an application seeking implement. There our stand is, my lord. Once lordship decides the issue, it will take care. If I succeed, my lord, the tender will go. If I do not succeed, his case will be considered.
But since IA is pending, some order is to be passed.
So, my lord, our
But
stand
Mr.
is.
Das, would you support us? Would you sail with the state?
Yes, I'm saying.
We are not filing any.
I'm a tenderer, my semblance of right is there because for go for fine, the entire process is stalled and I want my consideration. I don't want the right fit here.
You are not filing any pleading.
No, I'm not filing. I want that.
You can implement
matter
then.
should be heard and
We can implement since he is not filing any pleading.
I'm not filing.
Basically in the position of an intervener.
Technically, yes, my lord, not that.
Basically,
All
in
that
the
I
position.
said was not that he is a necessary party in the strict sense of the term. He may be a proper party.
Yeah.
Definitely a problem.
Hard. Item number 12, 2989. Oh, 1 minute.
Okay.
Let me dispose of this.
Mal,
In WPC 523,
There is no stay, no.
there is a stay order.
He was not there. Item number 7967 to the 7967 on A to due. 2989. Okay. I had Mr. D.K. Das, Learned Counsel for the applicant. Applicant. Architect should be Learned, the Deputy Solicitor General of India for the opposite party number 1 and 2. Mr. D. Hoytkal, Learned Advocate General, Assam, assisted by Mr. S. Bora, Learned Standing Counsel Homogra Hikka for the opposite party number 3 and 4, and Mr. K. Churi, Learned Senior Counsel, assisted by Mr. N. Gautam, Learned Counsel for the opposite party number 5. The instant interlocutory application has been prepared by the applicant seeking his implement as a party respondent in a connected writ petition, WPC number 7967/2022. Full stop. The connected writ petition has been preferred. Challenging. A tender process initiated by a notice inviting tender number so and so by tender number so and so dated 1/11/2022, whereby bids have been invited for supply and installation of dual desk and bench. Full stop. It is the case of the petitioner. It is the case of the petitioner in a petition. What is the main challenge in the petition?
The petition were challenged, my lord, the centralized procurement which the department wants to.
The bidding process ought to have been Ought to have been, ought not to have been. Ought not to have been. Quoted which though with the clauses indicated therein as the supply and installation of dual desk and benches are to be procured through the grassroots agencies. First up, Mr. Das, Mr. Das, and council for the applicant has submitted that in response to the NIT legal so and so, the petitioner or applicant had submitted its bid. First up, as the bidding process has been suspended due to passing of an interim order in the connected with petition, comma, the interest of the petitioner is likely to be affected in a prejudicial manner in the event the petition is allowed. Full stop. It is just submitted that since the interest of the petitioner is intricately connected with the outcome of the petition, comma, the applicant is a necessary party, and in such view of the matter, he should be his prayer for implement as a party respondent in the connected petition should be allowed. Also, Mr. Churvil and counsel for the opposite party number so and so petition has submitted that since the process, since the competitive bidding process initiated by the tender notice stated so and so has been challenged at the initial stage itself, comma, the presence of the applicant as a party respondent does not appear to be necessary. Full stop. Having considered, I have considered the submissions of the land council for the parties. Mr. Das has, land council for the applicant has submitted that he may be given the right to address as on his implement, comma, he is not going to file any further pleadings, and he will be supporting. He'll be supporting the stand likely to be taken on behalf of the official respondents. As the petitioner applicant hearing has participated in the competitive bidding process initiated by the tender notice dated so and so, I am of the considered view that the interest of the applicant will have a bearing with the outcome of the writ petition, connected writ petition, and accordingly, comma, as his presence does not appear to be unnecessary, comma, the instant interlocutory petition seeking implement of the applicant as a party respondent number so and so over in the connected writ petition is allowed. The registry is to cause necessary correction in the cause title of the connected writ petition and in the CIS accordingly. Mr. Das, learned counsel for the applicant, shall file an amended cause title in terms of the notification dated so and so by tomorrow before the registry. Same in other case. We'll take up
Yes.
7967.
My lord will kindly take a 523, my lord.
523.
Item five.
এটা বসাই কাগজ দিব
Well, basically, it's a tender for procurement of furniture for school. If your lordship would
both are same or different?
same, na?
Same,
Decks and desk.
desk and bench.
And mine is, my lord, dual desk and bench. Same thing. My lord will kindly come to page 26. That's the tender.
Hmm.
No, 523. Okay. Okay, no, huh? My lord will kindly come to page 26.
Yes,
Please have a look at the total quantity, my lord. 69,350. Then GOQ, dual desk and bench. Minimum average annual turnover of 2,100 lakhs. That means, my lord, 21 CR. Then my lord will kindly come to the next page. Estimated value of the work 69 crore 35 lakhs. Earnest money 1 crore 38 lakhs 70,000. So, my lord, naturally it is a bulk purchase. It can be, through the medium of school management committee, which the Central Act, my lord, recognizes as the agency to make the procurement. Now, please come to page 32. These are some of the attributes which shows, my lord, it's a bulk purchase. Page 32, eligibility criteria. I'll have your lordship's kind attention to G, H, I, and J. The bidder or their principal manufacturer themselves or through reseller must have the experience in supply of desk and bench of similar specification for at least 20% of the bid quantity in either of the last 3 financial year, that is 1920, 2021 and 21-22, to any central government, state government organization / PSU. I, bidder must have a minimum turnover of 20.80 crore in the 3 financial year. J, bidder must have positive net worth in 3 financial year out of the last financial year, that is so and so, so and so, so and so. My lord, since we are laying a challenge against the centralized procurement, my lord, therefore, my lord, we are assailing these clauses also, which are attributes of, my lord, bulk purchase. Now, my lord, we kindly come to 3 terms and reference, Roman small 3.
page,
Same page, my lord.
same page.
Yes, last sentence, in fact. Contentions arising out of issues not mentioned in this tender document will be resolved as per GFR 2017, CVC, Ministry of Finance, Government of India, and Assam Public Procurement Rule 2020. Mission Director, Samogra Hika Assam shall be under no obligation to accept the lowest quotation. Further, Mission Director, Samogra Hika reserve the right, etc., etc. Now, my lord, I have referred to this clause, last clause, the purport of which I will come little later. Now, my lord, this is the position. Now, I'll place before lordships that Government of India notification, my lord. Before that, let me place 2-3 other documents. Now, my lord, will kindly come to page 44. This is a, my lord, guideline issued by the Government of India, Ministry of Human Resource Development. It is Financial Management and Procurement for scheme of Samogra Shiksha. As you are aware, the scheme of Samogra Shiksha has been launched with effect from 2018-19 after subsuming the centrally sponsored scheme of Rashtriya Madhyamik Shiksha Abhijan, Sarva Shiksha Abhijan, and teachers education, with a view to provide guidance and uniformity in respect of mode of release and utilization of fund, budgeting and financial reporting, accounting and auditing requirements, and procurement procedure, etc. under this scheme. This ministry has developed a FMP, Manual for Use of the States, Union Territory Governments, and Implementing Agencies. This is very important, my lord. This ministry has developed a FMP, that means Financial Management and Procurement Manual for use of the states, union territories, and implementing agencies. A copy of the FMP manual is enclosed, and same has also been uploaded on the website of MHRD. The provisions of the manual would be mandatory. Kindly mark the words, mind. Accordingly, it is requested that guidelines of FMP may be followed in all future financial matters pertaining to schemes of Samogra Shiksha. And please come to the next page, my lord. B. All funds to be used for upgradation, repair and maintenance of schools, school grant, teaching, learning equipment, KGVV activities, and local management should be transferred to school, etc., hostel management committee, Gram Panchayat, or other village school level management for decentralization adopted by that particular state, union territory. Village school-based body may make a resolution regarding the best way of procurement. Involvement of community in procurement process not only creates a sense of ownership among the stakeholders, but also achieves transparency in the procurement. One of the, my lord, basic purpose which this guideline seeks to achieve is, my lord, community participation. The principal idea behind this, my lord, such participation will ensure a sense of ownership. And besides introducing, my lord, transparency and probity in the procurement process. Now, please come to, my lord, Roman capital 2. School KGBV related items to be procured. Please come to Roman 3. Furniture to government, upper primary school, secondary, higher secondary schools. Procurement of furnitures to be done by SMC, SMDC, equivalent bodies for urban, rural, urban areas. The specific mandate under the financial manual is, my lord, that the procurement will be made by the school management committee, as is being done in the current financial year in respect of Assam also. Present for the current financial year, this is the procedure they are following. Now, if your lordships will kindly come to clause 7.7 at page 46. Yes, my lord, 7.7. As a guiding principle, the financial threshold and type of procurement as provided in GFR 2017 is given below. No tender or direct purchase up to 25,000. 3-member committee in case of above 25,000 and up to 2.5 lakhs. Limited tender for work from 2.5 lakhs to 25 lakhs. Only when, my lord, the procurement is to be made for rupees 25 lakhs and above, it is only in such a situation, my lord, that open tender is envisaged. And naturally, my lord, for a school, the requirement won't go up beyond 25 lakhs. Therefore, presently, my lord, apart from my lord, the violating the FMP manual, my lord, it also, my lord, takes away the livelihood of the marginal businessman, my lord, who are living on the small business. Eventually, what happens, my lord? It goes to the hands of a particular contractor who will do the whole thing. So, my lord, there is an economic angle to this also. Because the schools are spread over across the state. Near the school, maybe there are some furniture outlets who annually do something, they're living on that. Now that opportunity will also go.
What is the specification?
My lord.
Is there any idea here?
No, my lord, specification for the present will not trouble your lordship. It's only dual desk and beds. Let us, I don't think that even will call for lordship's consideration. Then my lord will kindly come to page 47, the general financial rule, which is the basis for laying down this financial, my lord, guidelines, my lord. Please come to rule 154 at page 147, left-hand side bottom, my lord. Purchase of goods without quotation. Purchase of goods up to the value of 25,000 only on each occasion may be made without inviting quotation or bids on the basis of certificate to be recorded by the competent authority in the following format. Then, my lord, rule 155, that is between 25,000 and 2,50,000. And my lord, page 48, right-hand side bottom, rule 161. Sorry, page 49, my lord. Rule 162. In case of 25 lakhs and above, then it would be by way of an open tender. So the
162.
my lord, at page 49 on top.
It is up to 25 lakhs.
25 lakhs. Now, my lord, earlier, for procurement of, my lord, school uniform, a similar modus operandi was chosen by the state authority, my lord, which was put to challenge. And this honorable court was pleased to interfere with that decision, my lord. And that judgment we have annexed in our repetition as, my lord, annexure Roman 8, page 55. But only difference between that judgment and the present case is, my lord, there the money was coming from the central government. Here, my lord, in the state, in the affidavit, mission director has said that now state seeks to make the procurement from their own fund. Let us accept that position, my lord, that the procurement is being done under the state's fund. Even then, my lord, there is a requirement. In that judgment, it has been said, my lord, it is the school management committee who will make the procurement. And above 25 lakhs, one can go for, bulk required procurement. And in fact, my lord, after the judgment, it is being done by the school management committee. And again, my lord, school management committee is a, body which has been envisaged by the Act of 2009, Section 21. I'll come to that little later, my lord. Now, if your lordship kindly takes the affidavit filed by the state mission director, it starts at page 77. If your lordship will kindly come to page number 78, my lord, paragraph 3.
Question number 4 is mission director.
Yes, my lord. So in the context of the stand taken by the state, my lord, lordship will have to decide whether, my lord, still they are bound to follow the FMP.
Paragraph
3, my lord. The answering deponent, before answering the paragraph-wise averment of the writ petition, raises preliminary objection questioning maintainability of the writ petition on the following grounds. The entire writ petition is misconceived. Foundation of the writ petitioner's case is that notice inviting tender issued by the mission director Samogra Hikka Assam for supply of dual desk and bench is under centrally sponsored scheme by Union of India, leading to application of manual on financial management and procurement. Whereas the present notice inviting tender issued by mission director Samogra Hikka for supply of dual desk and bench is under state-owned priority development fund of the government of Assam. As such, manual on financial management and procurement is not applicable. In the present notice inviting tender dated so and so, procurement of furniture is regulated under Assam Public Procurement Act and the Assam Public Procurement Rule 2020 as such. Very foundation of the writ petition is misconceived and as such liable to be dismissed. Now, my lord, the principal stand of the mission director is, my lord, this is not a procurement under any central government fund. The procurement is made under the state's own resources. And the procurement is governed by the Assam Act and the rules. And FMP has no application. Now, on last occasion, my lord, I had given a complete copy of this financial management procurement. Hotel Lordship have that. Pagination to tato enake আছে।
हाँ এটা খুলি দিও manual this one
Yes, yes.
খুলিব পাৰিলে ভাল আছে 1 minute 1 minute, let me take it out.
Yes.
It has been stitched.
Okay.
বেলেগো আছে নেকি লগত দিয়ক নহলে হ'ব দিয়ক পিছত খুলিব দিয়ক সমগ্ৰ শিক্ষা and integrated scheme for school education.
My lord will kindly come to page 86.
86 of that internal page.
Yes, no, my lord, I think it is paginated.
Page
86, yes.
80.
Clause 2.5.2.
No. It has been repaginated.
Oh. Lordship will kindly come to clause 2.5.2. Internal page will be 13.
13. Yes. 2.5.2
towards the bottom, my lord.
Yes.
Heading is participatory planning process.
Mhm.
I'll just, my lord, draw your lordship's attention to some of the, basic features of this, scheme, my lord. Scheme envisages a bottom-up approach of planning as opposed to top-down approach, as it reflects the reality at the grassroots level. The planning process has to be participatory in nature, as planning not only creates a sense of ownership among the stakeholders, but also creates awareness and helps in capacity building of personnel at various levels. The plans so developed should reflect local specificity and educational needs and aspirations of the people based on consultative meeting and interaction with the community and target group. It is necessary that there should be documentation of the process of preparation of habitation level plan and evidence of the fact that they have prepared at the habitation level through participatory planning. Then my lord will kindly come to clause number 3.1 at page 18 internal, my lord. 3.1 financial management, allocation of resources. budget allocation to the states, union territories under the scheme would be made considering the annual budget allocation for the scheme at central level and the viable proposal received from the states and UTs as per norms. The state plans will be apprised and placed before the project approval board for approval. Anyway, my lord, this is regarding funding. This may not be that relevant. My lord will kindly come to clause number 3.6.1 at page 26 internal.
Page
Page
26.
26, my lord. Funding pattern. Even in case of, my lord, it is not that 100% funding is by central government. It is 60-40, but in case of northeastern states, my lord, it is 90-10. The current fund sharing pattern for the state government UTs with legislature is 60 and 40. In case of any states, it is 90-10. Then my lord will kindly come to 3.6.2, fund flow arrangement for various activities. Civil works up to 30 lakhs may be undertaken through SMC. So clear mandate, my lord. Then my lord will kindly come to the subpara. For activities at the school level, which are contracted at the state or district level, SMC should be provided a copy of the contract as well as copy of the work order in order to be able to monitor the works effectively. So my lord, the role of SMC is highlighted or rather re-emphasized. Then my lord will kindly come to clause 7.1 to 7.7 at page 123.
Internal page.
Internal page 50, my lord.
Yes, procurement.
Yes, procurement in Homogra Hikha for school education. The procurement activities under the Homogra Hikha shall be governed by procurement guidelines as provided in this manual, subject to overriding provisions as contained in GFR 2017 and Manual for Procurement of Goods and Works 2017 and Manual for Procurement of Consultancy and Other Services. The grants under the scheme are governed by various provisions in the GFR, and therefore adherence to GFR provision is also mandatory wherever applicable and may not have been explicitly specified in this manual. The principles of any public buying is to provide the work, goods, services of the specified quality at the most competitive price in fair, just, and transparent manner. Procurement of all works, goods, and consultancy services under the scheme would be carried out in accordance with principles, rules, procedures outlined in the chapter. Compliance with this procedure is mandatory so that it ultimately results in efficiency, economy, fairness, and transparency in procurement. While with subsuming of all the three schemes, that is SSA, RMSA, and teachers education into a single integrated school scheme of school education, Homogra Hikha for school education, and in order to cover all the aspects relating to other schemes together, a comprehensive procurement procedure has been underlined for implementation of the new scheme in its totality. The procurement activities under the new scheme will be at various levels, and bidding tender process as far as possible should be through GEM route, and the broad features of the procurement procedure under the scheme of the Homogra Hikha is, please come to Roman 3. Procurement of uniform being provided at the elementary level may also be done at this stage so and so, but involvement of participation of the community should be encouraged. Then my lord will kindly come to page 124, 7.6. It is mandatory to follow the procurement procedure prescribed in this manual for all procurement under integrated so and so. As a guiding principle, the financial threshold and type of procurement as provided in GFR 27 is given below. That is the, my lord, 25,000 then 25,000 to 2.5 lakhs, then 2.5 lakhs to 25, and 25 and above. Now, my lord, will kindly come to page 125, where the scheme also recognizes some amount of power of the state. Let us see, my lord, whether that will come to the rescue of the state. The states may, however, follow the financial ceiling prescribed by page 120, sorry, page 52, my lord, internal.
52 clause.
On this first subpara, my lord, the states may The
Yes.
states may, however, follow the financial ceiling prescribed by each state for various methods of procurement. MHRD may also prescribe financial ceiling for different methods of procurement from time to time, particularly whenever external funding agencies are involved in the scheme. In such cases, financial ceiling prescribed by the MHRD shall prevail and should be adhered to. It may also be noted that in case if the financial level threshold level of procurement have already been mentioned elsewhere in this manual, particularly relating to civil work, it should be adhered to by the state implementing agency. So, my lord, if the state has their own financial ceiling, that will be otherwise. It speaks of ceiling of the state, which must be consistent with, my lord, or maybe akin to, my lord, FMP. But whether state can choose to go for a, my lord, bulk purchase, disregarding the, my lord, right of participation of the people like the petitioner, a right which flows from the central scheme, my lord. Then my lord will kindly come to internal page 56. Roman I towards the bottom, my lord. Procurement of uniforms may not necessarily be entrusted at the school level, but should be as per the procedure mentioned in this manual. The state implementing society may decide the level of procurement and mode of procurement within the prescribed financial limit. All funds to be used for upgradation, repair, maintenance of school, grant, etc., hostel, etc., level of arrangement for decentralization adopted by particular state, union, territory. The village school-based body may make a resolution regarding the best way of procurement. Involvement of community in the procurement process not only creates a sense of ownership among the stakeholders, but also achieves transparency in procurement. The procurement rule for a school, etc., shall be either as per the financial rule of PRI institution or as determined, prescribed otherwise by the state implementing society wherever is applicable. Then, my lord, 2.3. Furniture to government primary school, secondary school, higher secondary school, procurement of furniture to be done by SMC, SMDC, equivalent bodies for rural urban areas. So, my lord, very, very specific. Then, my lord, will kindly come to page 61.
Yes.
7.16.1. The methods of procurement to be normally followed in Samagro Hikka are open tender, limited tender, single tender, without tender, civil work by community participation. Irrespective of the above method, which may be adhered as per the procedure and financial limit prescribed in this manual, but the following should have precedence. All purchase should preferably made on GEM, and if anything is not available on GM, e-procurement method should be adopted. Actually, my lord, one has to go by the government e-tender, that is no problem. Then subpara. States may, however, follow their own financial rule and financial ceiling prescribed under those rules in place of GFR after due approval of the executive committee in this regard. Such approval should mandatorily be intimated to MHRD at the beginning of the scheme. So, my lord, state may also have their own financial ceiling. They may also do their procurement in accordance with those ceiling. But, my lord, before undertaking to make any procurement, the state will have to seek approval from the MHRD at the very beginning. First of all, my lord, like FMP, the state must have its own scheme. Whether there are. Then my lord will kindly come to 140, page 75. (7.29) Misprocurement. The goods, work, services that have not been procured in accordance with the prescribed procedure outlined in this manual or other state government procurement procedure as the case may be, shall be treated as misprocurement. The expenditure incurred on such procurement shall not be eligible for financing from the scheme funds. So, my lord, not only the financial FMP prescribes a method of procurement, my lord, it also recognizes the power of the central government to, my lord, describe a procurement as a misprocurement, and which event the central share will not be released, which is 60%. And in case of Northeastern and other, my lord, special category states, it is 90%. So, my lord, end of the day, what clearly emerges is merely because state is making some procurement of its own, my lord, state cannot, disregard the FMP mind, which essentially, my lord, lays down a decentralized procurement process. And the state, I don't think, can question the wisdom of the government of India in this regard. Now, which is that state's, my lord, financial ceiling limit? In their affidavit, they have pleaded none. They say that they will make their procurement in accordance with the Assam Act and the rules. Now, let us come to the Assam Act and the rules. This is, my lord, last time we have given a copy, my lord.
We have the, Act order rules.
Act, my lord. First, I'll have your lordship's kind attention to the Act. Please come to page 52, my lord. Section 52. The provisions of this Act shall be in addition to and not in derogation of the provisions of any other law for the time being in force. So, my lord, the intention, legislative intention of this Act is not to, my lord, override any other procurement law in force. Rather, this should be treated as a complementary of each other. So, if a procedure consistent with the central guidelines is being followed throughout the country, I don't see any reason why government of Assam should, my lord, depart from that. The act itself says these are in addition to the, norms which are prevailing. And in any case, my lord, the state's power is always subject to the central power. In whatever manner, my lord, do we conceive in our constitutional setup.
What is the state-owned priority development?
They say, my lord, they have not explained anything. They've only made that statement in their affidavit. In other words, they would like to say 100% fund is of the state government. There will be no element of central fund that is 60% or 90%.
But whether NIT here and in the other petition is one and the same.
Yes, I can agree. Oh, here it is central fund.
As per the statement in paragraph 3,
Yes,
they are saying that it is a fund of the
state government.
state government.
Own priority development.
Huh.
State owned priority development.
Is there anything about the own priority
No,
development?
they have not gone beyond that. They have simply made a statement that procurement is made out of the fund that is SOPD, and they are following, my lord, public procurement. Sorry, under this act. Now, my lord will kindly come to the act. So, my lord, what follows from this act is that these provisions are not meant to override any central prescription. These are in addition to the existing norms. Meaning thereby, my lord, when you are professing that the procurement is under the Assam Act, then Assam Act does not, my lord, arrogates to itself any special power. That they will do away with the decentralized, procurement as is envisaged under the FMP. Now, my lord, it also says that state must have their own ceiling. On the contrary, my lord, I'll place two policy of the government which will clearly reflect otherwise, my lord.
1 minute.
And it's- তারিখ আছে নি? 12/22 12/12 My lord will kindly have this. This is again a document guideline issued by the Assam Sarbahikha Abhijan itself, my lord. Please have that document, Assam Office of the Mission Director, guideline on procurement and distribution of uniform. Now, if your lordship will kindly come to procurement and delivery 2, towards the bottom, my lord, on the
One.
first page.
1 minute. This is Rashtriya Madhyamik.
No, my lord,
No.
kindly come to the other one. I'll come to that, the other one.
Sarbahikha.
Assam Sarbahikha, yes. If your lordships will kindly come to B, capital B, the heading is procurement and delivery. The lordship got it, my lord. It's dated 12/12/22. First page, my lord.
12, 12.
It's handwritten, my lord, after towards the bottom.
Oh,
Yes.
okay.
Kindly come to, my lord, that B, procurement and delivery. Now, B2, a decentralized manner through SMC, SMDC only. No centralized procurement at any level. It is in respect of uniform, my lord.
Yes.
But nevertheless, it is the Ahom Khorbaikha vision they themselves are saying. It can't-
Yes, that is where page 44
Yes.
of the read petition.
Yes, my lord.
All these schemes have been subsumed now
Into one.
into one.
Yes.
Homogra Hikha.
Ahom Khorbaikha.
So these are all now in Homogra Hikha.
Yes.
So
Correct.
this is prior to,
No, well, this is prior.
okay.
Ah.
When it was
It was, I think, on 12,
2018, 19.
12/12/22. So, my lord, to say on oath that because there is own fund, that does not make any sense, my lord. You yourself is saying there is no centralized procurement. Now, if a lordship will kindly come to the other document, Rashtriya Madhyamik Shiksha Abhijan. Now, the same mission director is writing to the district program coordinator. It's a communication dated 3rd of February 22. Administrative approval and financial sanction for procurement of furniture under Rashtriya Madhyamik Shiksha Abhijan for civil work activities under so and so. Please come to serial number 5. Approved amount-wide sanction letters shall be credited to the joint bank account maintained by President and Member Secretary of the SMDC of the concerned school. Then serial number 8. Works to be allotted as per procurement procedure laid down by the Finance Department from time to time.
This is furniture.
Yes. All of a sudden, my lord, what is the change which has taken place? That, my lord, the state is taking a stand that that we are also empowered to make, centralized procurement. Then my lord will kindly come to page number 52 of that and FMP for a moment, my lord, once. Page 52, which I've already placed. I would like to paste it once again.
Yes. Yes.
The states may, however, follow the financial ceiling prescribed by each state for various methods of procurement. MHRD may also prescribe financial ceiling for different methods of procurement from time to time, particularly when the external funding agencies are involved in the scheme. In such cases, financial ceiling prescribed by MHRD shall prevail and should be adhered to. Now, since it is a state-funded, my lord, therefore the subpara will not come. But state may also follow their financial ceiling prescribed by each state for various methods. So let's place that financial ceiling. Which is that ceiling, my lord? They can't say we will not follow this. My lord, please test our argument from one perspective, my lord. Which way, my lord, public interest will be better served? My lord, in a 226 proceeding, in a public law remedy, your lordship decides to enter into the marriage because there is an element of public interest. Now, a single tender, entire money will go to a single individual or a single entity. or a legal entity. Here, my lord, across the state, all the small time businessmen will get some work and they will, it will help them in their, my lord, earning their livelihood. The public interest lies where, my lord? In enriching a big businessman or, my lord, in distributive justice. Whereas, by end of the day, it's a public law remedy. Lordship will also test it from the perspective of, my lord, Article 21 of the people like petitioners before lordships. Now, when, my lord, the present dispensation, even present financial year, it is the SMDC who is making the procurement. Which is that good reason why state wants to depart? So therefore, my humble submission is, my lord, unless state can show that they also have come up with a financial ceiling where they should also encourage, my lord, decentralized, and beyond certain limit, they would like to go for, my lord, centralized, procurement. I don't think states should be otherwise permitted.
Is there any affidavit other than this one
No, my
from the
none,
state?
None. No, in my case, there is none.
No, regarding this state-owned priority development fund, there is nothing, only this much. Paragraph 3 of the affidavit and any other document?
No, my lord, they have relied upon that affidavit, nothing else. Now, my lord, the state also professes that they rely upon the Assam Act of Assam Act. Please have the act for a moment, my lord, section 6. Section 6. The procuring entity shall not establish any requirement aimed at limiting participation of bidders in the procurement process that discriminates against or amongst the bidders or against any category thereof, except when authorized or required to do so by the Act or the rules or guidelines made thereunder or by any provisions of any other law for the time being in force. Then, my lord, will kindly come to 2. In addition and without prejudice to any existing provision of enactment of procurement preference policy, Assam 2015, state government by notification in this behalf, provide for mandatory procurement of any subject matter of procurement from any category of bidders and purchase or price preference in procurement from any category of bidder on the following grounds, namely promotion of domestic industry, socio-economic policy of the central government or the state government, any other consideration in public interest in furtherance of a duly notified policy of the central government or the state government, provided that any such notification shall contain a reason justification for such mandatory or preferential procurement, the category of supplier chosen, and the nature of the preference provided. So Assam Act itself envisages a purpose, my lord, that in making the procurement, you must have due regard to the public interest, which is in furtherance of a duly notified policy of the central government. So, my lord, the FMP has a object to achieve. Amongst others, my lord, the most important objective is there has to be community participation, my lord. And that can be ensured by decentralized, my lord, procurement. It brings in or instills, my lord, a sense of participation. So these are the my lord, when they say that they rely upon this act, these are the provisions of the act, my lord. My lord, I am conscious of the fact it's not an open and shut case. It's a case, my lord, where, my lord, in my humble submission, my lord, lordship will have to cull out the principles which are incorporated in the policy and the objective of the policy, and then to apply those principles into the facts of the case. Therefore, my lord, I will not, to sum up my argument, my lord, though in the decision rendered in the case of school uniform, which was dealt by the learned coordinate bench of this honorable court, was in respect of a centrally funded scheme, my lord. Here it is not, admittedly, it is all by way of an state money, state's own fund, my lord. But even then, my lord, they're bound to follow the FM. They cannot deviate from this. Merely because the fund, even in otherwise in central government scheme also, 40% money is theirs. Therefore, can they say to the extent of 40% procurement will not follow the central prescription? Therefore, my lord, I think a decentralized procurement will be in public interest. It will benefit a larger sections of the society. And in a situation when, my lord, inflation is ruling the roast, I think, my lord, such a course will certainly subserve public interest. And finally, my lord, that section 21 of the Act. Yes, my lord. 21 of the Act of 2009,
Oh, take it up.
RT Act, Right of
RT.
Children to Free and Compulsory Education.
Nine. Yeah. nine. So what's the value? Huh? Section
21, my lord. Section 20.
Do you have any book? This is illegible.
Yes, not legitimate. I think Torun Shuti has come up with his part 2, my lord. This must, we should continue.
This code does not have that book. Section 21 of Right to Children.
RTA actually কি হবে? Abbreviation টুকুনি বুদ্ধি নিমিতে। কোথায় confusing? হ্যাঁ?
21. School management.
21 and 22, my lord.
Yes.
Yes. A school other than a school specified in subclause 4 of clause N of section 2 shall constitute a school management committee consisting of the elected representative of the local authority, parents or guardian of children admitted in school and teachers, provided that at least 3/4 of the members of such committee shall be parents or guardian. So school management committee includes everybody, man. That's why it says that sense of, my lord, ownership. Provided that 50% of the members of such committee shall be women. School management
It
committee
is
shall
there.
perform.
Oh, in this book. 50%.
Yes. Provided also that 50% of members of such committee shall be women.
Yes.
School management committee shall perform the following functions, namely, monitor the work of the school, prepare and recommend school development plan, monitor utilization of grant received from the appropriate government or local authority or from any other source, perform such other function as may be prescribed, provided that school management committee constituted under subsection 1 in respect of a school established and administered by anywhere not concerned, all other schools as defined in so and so shall perform advisory function only. 22. Every school management committee except school management committee in respect of a school established and administered by minority, whether based on religion or language, and an aided school as defined in so and so under subsection 1 of 21 shall prepare a school development plan in such a manner as may be prescribed. School development plan so prepared under subsection 1 shall be basis for plans and grants to be made by the appropriate government or local authority as the case may be. Now, my lord, this FMP and others, my lord, this has been framed only to give effect to the purpose of section 21 and 22. So, my lord, can state of Assam say that we will not follow the prescription of the FMP and more especially, my lord, section 21 and 22, which is a central act. They are bound to follow it, my lord. I think, my lord, this is too irresponsible a stand of the state government in my humble submission. It's too irresponsible a stand. Having regard to the, my lord, the subject matter. It is the government of India, my lord, who has got the pivotal role to lay down the planning. And they have done it. And their idea is it has to be decentralized. There has to be participation of the public. I don't think, my lord, these, objectives can be set at naught by a bureaucrat by filing an affidavit. And the affidavit is, my lord, very, not very clear, my lord. They must, come up with some more specific details, my lord. There is not forthcoming. Therefore, to assert that since it is our fund, we'll choose the procurement, I don't think that is the right approach. That is my humble submission, my lord. Therefore, in my humble submission, my lord, this tender process cannot be allowed to proceed any further. As presently, my lord, procurement is being made, as was done by this honorable, a coordinate bench of this honorable court in case of, my lord, school uniform, similar direction should be issued. That's my humble submission, my lord. Deeply.
May it please. I'm appearing WPC 7967.
আৰু এই এখন বেলেগ এখন কাগজ দি দিম।
My lord, the NIT here, I am challenging basically on 4 grounds. Number 1, it is in violation of the manual of financial management and procurement rules, which my learned colleague has already explained.
Violation of GSR.
Financial
FMP.
FMP, yes, financial management and procurement manual. Number 2, Number 2, it is in violation of the GFR, General Financial Rules. Number 3 is, it is in violation of section 21 and 22 of the Right to Education Act. This is a long name, my lord. Most probably it is not called Right to Education Act.
Okay.
My lord.
Section
Let me
20 and 22. 21 and 22.
22. And it is, fourthly, it is in violation of the MSME Act. I'm sorry. While explaining this, before that, my lord, I will take your lordship to page 27 of my writ petition. Just to have a look, my lord, what is the back? The estimated bid value, I'm so sorry.
Yes.
Estimated bid value was 32.73 crores. 31.73 crores.
Which part?
31, isn't 30. Bottom, my lord, page 27, estimated bid value as a lordship. It is 31. 30, I'm sorry, 31.73 crores.
Yes.
For the supply of dual decks and bands, item category has a lordship. Then minimum turnover
Yes.
Your lordship will kindly come to page 34.
Hmm.
Minimum turnovers, bidder's turnover must be 9.52 crores,
Page 34.
page 34. Bidder turnover, my lord, in the middle portion of the page, bidder turnover.
Ah.
Average annual turnover should be 9.52 crores per year for the last 3 years. And what they have done, bottom below, total quantity is 31,736 as well as sugar. And for all the 30 districts, bottom below, delivery place. That means all districts have been clubbed together. Now your lordship will kindly come to page number 50 because my learned colleague has already explained in details. Here is a letter. This is a central fund, my lord, coming in. These are a letter from the secretary, HRD department, as a lordship. Subject is Manual of Financial Management and Procurement. As you are aware, the scheme of Samagra Shiksha has been launched with effect from so-and-so of subserving the centrally sponsored so-and-so schemes. Your lordship has already gone through. Uniformity, then your lordship says that serial number 2. Accordingly, it requested the guidelines of FMP may be followed in all future financial matters pertaining to the scheme of Samagra Shiksha. As a lordship. Now, your lordship will kindly see an issue sometimes comes up whether this FMP is we are mandatory or not. This your lordship will kindly see at page 66. This High Court has already held
Yes.
paragraph 20, my lord.
Paragraph
20. This is our court judgment in the other case.
20.
Yes.
Page 67.
I'm so sorry, page 67.
Yes.
A reading of the communication dated 6/8 so-and-so issued by the Secretary MLD at New Delhi takes the matter beyond any pale of doubt that the state implementing agencies would be under a legal obligation to adhere to the FMP, has your lordship. So that now issue is settled till now, because it's a coordinate bench, I should not say it is. Now this is what was decided. Now your lordship will kindly come to page 52. Now, the FMP relevant page, your lordship will see. My learned colleague has already read out 7.5 that it includes the furniture and the. Now, 7.6.
Yes. Yes.
It is mandatory to follow the procurement procedure prescribed in this manual for all the procurement under the integrated scheme, that is that Samagra scheme and Girls Hostel. As a guiding principle, the financial threshold and type of procurement as provided in the GFR 2017 is given below. Now the manual refers to GFR 2017. Procurement type up to 25,000, no tender. 3-member committee comes in between 25,000 to 2.5 as a lordship. Limited tender, then service contracts, then direct. If it goes beyond 25 lakhs, then it will be open tender. Now, what exactly has been done? Your lordship will kindly look at para 13, page 11 of the writ petition. Now, This manual, so long we have found that this FMP is mandatory. The procedure has to be followed as per the FMP. Now, what exactly is sought to be done is in para 13, page 11. Here's a short paragraph. Can I read, my lord? If your lordship so permits. That as per the bid document, the furniture, dual decks and bench is supposed to be delivered at 1,442 numbers of schools in 30 districts within the state of Assam. That your lordship is already know, all districts have been clubbed together. But why? The tender issuing authority, with an intention to accommodate some interested firms, companies and entrepreneurs, very smartly clubbed 1,443 numbers of schools as one unit. That means all schools becomes one unit, so as to avoid and subdue the provisions of 7.7. Your lordship will kindly underline the 7.7 they are relying on the FMP. The bid value of the tender as per the tender document has been shown as 31 crores so and so, and the number of schools have been shown as 1,000 so and so, which reflects that the procurement threshold for a particular school will be below 25 lakhs. That means 31 crores so and so divided by so and so school. I am finding out the average. It becomes 2,19,000, my lord. So if they are following the FMP, then it becomes a different procedure. If they club it together so that they can come out of this FMP procedure. As such, the tender issuing authority club so and so. Now your lordship has seen. Now your lordship will kindly come to page 53 again. Because FMP mentions about GFR at page 52. Now GFR, your lordship will see rule 153. As your lordship. Rule 153, Roman 3.
Yes.
The central government may by notification provide for mandatory procurement of any goods or services from any category of bidders or provide a preference to bidders are the grounds for promotion of locally manufactured goods. Now, in the FMP, now your lordship will kindly see that the participation should be there. Now, this Roman 3 is in consonance with MSME Act. Your lordship will see MSME Act. MSME Act, I take your lordship to section 11 of the MSME Act.
Section.
I can give another.
No.
This Roman 3 is in consonance of section 11 of the for facilitating promotion and development of micro and small enterprises. I am a small. The central government or the state government may by order notify from time to time reference policies in respect of procurement of goods and services produced and provided by micro and small enterprises by its ministries or departments, as the case may be, or is aided institutions and public sector enterprises. Now, till now, what I wanted to bring home is, we have an FMP. It says locally. FMP mentions about GFR. GFR rule 153 says local production. Now, what has happened? Your lordship will kindly see how they have dealt with it. May I take your lordship to their affidavit? If your lordship looks at paragraph for page number 89.
Yes, 89.
My lord will see, they have said that with regard to the statements made in paragraph 17, can I pause here for a moment? Paragraph 7, they are replying, my lord, their affidavit, the director, mission director. With regard to the statements made in paragraph 17, can I pause here for a moment? What was page 17? I take your lordship to page 13 of my writ petition. There was a specific plea, the first sentence. No one can say that I did not notice this sentence. They are replying to this paragraph. Has your lordship got page 13? That petitioner begs to state and submit that as per rule 153. Now your lordship will compare with their paragraph 40. Now they are saying, with regard to the statements made in paragraph 17 of the writ petition, the deponent begs to submit that since the bid value of so and so of the tender in question exceeds the threshold, as your lordship. And what was my contention was that you please refer to 153. He does not deny that it is not applicable. Your lordship will again see at page 53, rule 153, Roman 3. He avoids that. The director, mission director avoids this. Do something else, to say something else. Roman 3, my lord, has your lordship. Now in paragraph 17 in reply, he avoids this. He neither say it is not applicable nor say that it is applicable. Has your lordship. Now, your lordship will come to rule 155. Of the rule 155 is at page 53. This is regarding 153 is nothing on affidavit. Has your lordship. Purchase of goods by purchase committee, purchase of goods 25,000 up to so and so. Manufacturing of a duly constituted local, has your lordship.
Yes.
Now, FMP says you should follow GFR. And GFR language 153 is quite clear. What is to be done? Now, in order to, how does he substantiate it in paragraph 14? He said it is nothing wrong to make it as a 1 unit.
What is rule 173?
My lord. Rule 173. Huh? Transparency, competition, fairness, and elimination of arbitrariness. I'm obliged, my lord, most probably I missed out this
173.
173. I'm obliged to your lordship because I missed out this rule
173.
of the GFR at page 54. Right? Page 54, yes. At page 54, my lord. Even not only these rules, there is also, it says that there must be transparency. Now your lordship will compare this with paragraph 14. He said we have made it 1 unit. He does not say that why 153 is not applicable, why 154 is not applicable. Now, can I take your lordship to page 86 of the government affidavit, or not direct mission director's affidavit? Para 11.
Page 86.
My lord. Page 86.
Yes, para 11.
My lord. With regard to the statements made in paragraph 14 of the writ petition, the petitioner begs to submit that having bank account number so-and-so in so and does not render the school autonomous in as much as they are controlled and run by the state government. They are silent about the Right to Education Act. The decision to go to open tendering is in consonance with the provision of 7.7. Your Lordship will kindly underline 7.7. This particular argument was taken in the earlier writ petition, and how it was handled with your Lordship will see at paragraph 29, page number 69. This particular contention was raised at page 69, paragraph 29. Is the
Page 69.
9 of the earlier judgment, my lord, how it was dealt with. Now they want to take the support of 7.7. And this is the same argument in the earlier writ petition.
Yes.
Paragraph 29. A plain reading, I'm sorry. A plain reading of 7.4 and 7.7 would go to show that while the state has been left with the liberty to make procurement through single implementing agency, they are saying single implementing 7.7, yet under subclause Roman 3 of 7.4, which your Lordship has just now gone through, my lord, that local manufacturers. Involvement and participation of the community has been encouraged. In other words, 7.43 provides that the level of procurement may be decided by the implementing agency, but the same should aim at encouraging community participation in procurement process. The aforesaid provision, in my opinion, lays down a policy statement of the government and therefore cannot be ignored by the implementation. Now, just pausing here for a moment. When I raise the issue of Rule 153, Sub-Rule 3, they do not reply. When I say 7.4, he points out 7.7. 7.7 and 7.4, how it is to be interpreted, this court has come to already in paragraph 29. Now, your Lordship, again, I am dealing with their affidavit. Your Lordship will kindly see paragraph 8 at page 82. Can I have some water? Second subparagraph. May I read one? Further, the deponent begs to submit that the decision of the tender issuing authority to go to open tendering was based on CBC guideline. Now, why do they say CBC guideline? Your Lordship will look at page 80, 2 pages before that. The first paragraph. In strict adherence to the said norms as stipulated by the CBC, the tender issuing authority kept the minimum 9.52. Has your Lordship got? Your Lordship will look at page 82. They say that they have adhered to CBC guideline. And what is that CBC guideline? Your Lordship will get it at page 80. Because fixing of minimum annual turnover, has your Lordship. Now, they say read with FMP. It is their case. Page number 80. Their case CBC guideline for annual turnover. Read with FMP and read with GFR 2017, has your Lordship. Now your Lordship will kindly look at para 14 at page 59.
Yes, 59.
My lord. My lord, history. I'm sorry, my lord, page 87, I'm sorry. Page 87, my lord, in the affidavit, their affidavit. Page 89. I'm sorry, para 14 at page 89.
Yes.
That with regard to the statements made in paragraph 17 of the writ petition, the deponent begs to submit that since the bid value so and so in question exceeds the financial threshold of 25 lakhs. And how does it exceed? I have already explained. They have clubbed it together. Therefore, rule 155 of the GF shall not apply. And what is rule 155 is, my lord? That is at page 53. Now they found out a modus operandi how to keep the GFR 153 out. Whereas the FMP says the classification threshold, their GFR says so. Now, your lordship will also find they have made a statement in their lordship will bear with me for it. Yes. Your lordship will now see paragraph 8 at page 82. They are following, they are so transparent, they are following CBC, read with FMP, read with GFR, then again makes a categorical statement. Last sentence, my lord, last line of page 82. Be it stated herein that the GEM is open for all categories and the registered MSMEs can also participate. Now, your lordship, here comes the question. You make say annual turnover and justify that 9 crores. And you expect an MSME under the MSME Act 25 lakhs to participate. Is this the condition? Now, next paragraph. It is further stated that concession and exemptions will be provided. You have issued that NIT. There is no whisper about an MSME. You have fixed 9 crores by clubbing all the different categories. In violation of the FMP and this. Now in order to take guard of the MSME factor, they say it will be provided. Has your lordship got that language? Now, and MSME Act also section 11 says it is your duty to make a policy decision for those. Now say it will be made. And they issue the tender without making that. I am obliged, my lord. This is for the central fund. And my lord, last one. I'm sorry. In the earlier case, now they are doing it, right? They are doing it through the decentralized way. In the earlier case regarding dress materials, they wanted to consolidate it for the entire states for a particular party, in favor of a particular party. This starts at page 59. My learned colleague, Mr. Chaudhary, Mr. Anand Datta, my learned, they are all appearing. Mr. Mishra was appearing. I will not take your lordship's valuable thing. Then paragraph 4, how it all came into thing. Paragraph 4.
Yes.
Then paragraph 6. Paragraph 9, my lord. Most probably it slipped out of my learned colleague. He is the person, Mr. Chaudhary, paragraph 9 at page 63. Paragraph 8, I'm sorry. That 7.4 and 7.7. Now the mission director wants to take guard of the 7.7. This was a submission at page 63 of Mr. Chaudhary. Then The additional Advocate General submission is at page 64, the government stand. Paragraph 11. He relied on some decisions also. Paragraph 14 is Mr. Mishra's submissions. Mr. Mishra appeared for the private part. Then paragraph 16, paragraph 17 onwards, 16 onwards, 16, 17, 18, 19, 20, my lord. This is how it ultimately, paragraph 29, 7.4 versus 7.7. Paragraph 48, can I read, madam?
Paragraph
48.
yes.
Paragraph 48, what is the public law element? Mr. Chaudhary was arguing actually that was a decision in paragraph 40. It is a common, it's common refrain that the process of industrialization is yet to reach the desired level in the state of Assam, and therefore there can be no denying the fact that a large number of unemployed youths, entrepreneurs, traders, and business houses in Assam are heavily dependent on government contracts for earning their livelihood. Whether or not a person is successful in a tender process found floated by the government is a different matter. But to design tender conditions in a manner and altogether restricts participation of such manner persons engaged in the concerned trade or profession, in the opinion of this court, would be highly discriminatory and therefore violative of the equality clause enshrined in Article 14, and this is also discussed. But basically what happened, now they have taken guard of in this affidavit by saying, we will protect, we will take care of the MSMEs. After floating in the affidavit, he says in that paragraph, your lordship has said. My lord, with this, my lord, I conclude. Huh? Right to education. My lord, I have right to education. Mr. Chaudhary, I am adopting that Mr. Chaudhary's argument that Right to Education Act envisages SMEs, the state or as the MCs. Right to Education Act also envisages a fund. Right to Education also makes that they are the people who should make their plan. This is already actually ultimately repetition of my argument. My lord, only one thing I want to point out. A submission may be made that as if we are challenging the terms of the agreement, the terms of the NIT, or we are not, actually the process of issuing the NIT. We are not selling, it cannot be said terms, because a very recent decision, it is my duty as a senior counsel, 2022 6 SCC, page 127, there a peculiar stand was taken. A law was laid, not, I should not say what peculiar, a law was laid down that if you, there, what happened is a road construction. A person, he gave a bank guarantee in respect of a tender which was earlier revoked, the same bank guarantee which was modified. Then it was cancelled, he went to the High Court. Then in this case, what happened, the Apex Court says that is a public, ultimately public suffers. We should not go into this. It should better go to a civil court. And now, very recently, this Apex Court has again clarified that this particular judgment has been misinterpreted by the High Courts for not entertaining any writ petition in the realm of tender. That is Joy Bholenath Construction versus Chief Executive Officer, Jila Parishad. This is a case from Maharashtra. Maharashtra High Court referred to this decision of the Apex Court, saying that we are not entertaining any matters relating to tender. Then that matter, Joy Bholenath went to Apex Court. In Joy Bholenath Civil Appeal number 4140 of 2022, it says that dismissing the order passed by the Maharashtra High Court saying that our judgment has been misinterpreted. It is not that every case you go to civil courts. May I, my lord, so that as a senior counsel, my lord, I should place it from my side only. Because we are basically challenging the process of issuing the tender, not the tender clauses, clause by clause. SCC case is the first case. Now I have found out in that Joy Bholenath, the apex court has said that our judgment has been misinterpreted. Might be one day some submissions may be made that because it's a very recent case, somebody may point out this SCC and Joy Bholenath may not come into the picture. I'm obliged. I thought it is fair, it will be fair on my part to point out this. It's a very tough language as it appeared in the first SCC case. Saying that you go to civil court. We have no business to do it. It's a public, ultimately public suffers. Road construction matters. Bank guarantee, who is success. I am not on successful tender or unsuccessful tender. I am an MSME unit. My lord, I am obliged for your lordship's present hearing. Can I just leave for a minute? Come on, election. My learned colleague will be there. Bear over. Election. My lord, I am told my learned colleague, Mr. Chaudhary, will have a right.
Right to reply before.
I'll come back, my lord. I have a part at my book.
আগৰ ফাইলটো বহীখন আছিল না বহীখন পোৱা আছিল না বহীখন এইটো নহয় এইটো ইয়াতে আছে
Yes, Lord.
Which one, Mr. Kane Chaudhary
Yes,
or Mr. KP
one by
Patel?
one, Lordship.
Kane Chaudhary.
Kane Chaudhary's case, Lordship, the 523. So what I have understood from the submission of both the senior counsels, Lordship, that they are basically agreed that instead of bulk purchase, we should go to each school and buy the furnitures. So whether it should be done school-wise or it can be centrally procured, that is the core question. And in support of that, they have relied upon various provisions of law which are governing the field, and they are basically indicating the law which is favoring them. There are other options also given in the same rules that the state government can opt for the other process also. That means bulk procurement. That provision has not been placed before this honorable court. The state has the option to either to go for decentralized procurement or centralized procurement. Both the options are open to the state, and state has adopted the process which is more beneficent, more cost effectively, and on top of that, the quality of the products are assured. From that perspective, the state has taken the decision that we should go for centralized procurement instead of having decentralized procurement through the various schools, through their school management committees. And there is already a process in place where there are certain norms laid down by the state government that when there is a procurement of more than 20 lakhs, Lordship, it has to be done through e-procurement. And whether the school management committees are well equipped to follow the process as required for e-procurement or through the portal of GEM. So various nitty-gritties and various technicalities have to be taken by the government while taking a call in which process it will be more beneficial and it will be convenient for the state to procure the goods. So they have.
When e-procurement is mandatory?
India e-procurement is mandatory, Lordship. There is a finance department's notification office memorandum I'd like to place. These are not part of the affidavit. That is what is troubling me. If Lordship wants, I can file a short affidavit by annexing all this, but we'll furnish a copy to the other side also. This notification was issued, but it was a long pending, this was already there. May I read it, Lordship? This was issued on 9th June 2023 in partial modification of the office memorandum dated 16/12/2021. The Governor of Assam is pleased to re-notify para 4 and 6 of the OM dated 5/8/2016 as follows. Henceforth, all administrative departments of Government of Assam and its subordinate directorates, offices, agencies, including institutions receiving grant in aid from Government of Assam, shall adopt e-procurement for procurement of all goods, services, and works for all tenders value above 20 lakhs and above. However, the following items shall remain exempted from the purview of this amendment: all emergency procurements and urgent work, procurement of 10 statutory autonomous councils, various autonomous councils are named. All procurements above 50 lakhs will necessarily be through e-procurement mode, as was the case before and above. Para 6, the procurement of goods and services of value less than 20 lakhs may also be procured through e-procurement mode at the discretion of the procuring entity. The head of the department are requested to circulate a copy of the OM to all procuring entities under their control and immediately.
But this
But
was of 9
This was,
June.
this was 9 June 20, but I have to produce this 2016 also. The same was
2021.
21 and prior to that 5/8/2016.
Hmm.
From that time, from 2016 onward, it is 20 lakhs and above. I'll place that, Lordship.
Okay.
In course of the hearing, I have procured this, Lordship, but I know this is the norm from 2016 onwards. So, before going,
Because otherwise, if this is correct,
Lordship,
this 9/6/2022,
yes, 23.
23.
This is a modification,
Ah.
actually.
So para 6
Para
of this one,
Yes,
20 lakh, less than 20 lakh, may.
at the discretion of the procuring entity.
Right.
This advertisement of the
This is
instant case
prior to 9/6.
is of 2022. But if I produce that 2016, where this norm was still there, it certainly strike my mind, Lordship. That's why I got it. But the original one, the first one also, I'll have to place it.
Because prior to this, there are two other.
Yes, two others. Now, if Lordship is pleased to, I'd like to place the affidavit first, then the legal provisions, statutory provisions, the FM, the manual also. So far as my learned senior friend Lordship K. Chaudhary's case is concerned, the fund is totally belong to Assam. So there is no such requirement of having followed that 90:10 or any other schemes under the central government. And therefore, this particular financial management and procurement manual, Lordship, which was issued by the Ministry of Human Resource Development, it will not govern the state of Assam's affairs. After all, we are living in a federal structure system. So paragraph 3, if Lordship is pleased to look at, the entire writ petition is misconceived. The foundation of the writ petitioner's case is that the notice inviting tender dated 13/1/2023 issued by the MD Samuddra Shiksha Assam for supply of dual desk and bench is under centrally sponsored scheme by the Union of India, leading to application of the Manual of Financial Management and Procurement. Whereas the present notice inviting tender dated 13/1/2023 issued by the MD SSA for supply of dual desk and bench is under the state-owned priority development. This is a special fund created for various roads and various state government projects. So these schools belong to the government of Assam. All these schools actually is owned by the Department of Education. And in some schools, we have to supply with contractual teachers and various other schemes, central governmentally, pan-India, they are implementing certain schemes. For that purpose, SSA is the nodal agency. It is an agency between the central government and the state government, and this nodal agency is a society under the society's registration. Is under state-owned priority development fund of the government of Assam. As such, the manual on financial management and procurement is not applicable. In the present notice inviting tender dated 13/1/2023, procurement of furniture is regulated under the Assam Public Procurement Act 2017, Assam Public Procurement Rules 2020. As such, the very foundation of the writ petition is misconceived, and as such, liable to be dismissed. Pausing here for a moment, Lordship, they were trying to indicate various provisions of the financial management manual, but not a single submission they have indicated that we have violated any of the provisions of Assam Public Procurement Act 2017 or the rules framed thereunder. The writ petitioner has no legal right to challenge the terms and conditions of a tender process being the settled position of law. As such, the writ petition is liable to be dismissed. Although they are finally, my learned senior friend, Mr. Pathak said that they are not challenging any of the terms and conditions. If that be the case, nothing remains in my humble submission. According to them, the whole process, Lordship,
Coordinate bands has
coordinate
made
bench.
some statement. Say, is it challenged?
It was not challenged because that was related to a particular year. Because that year the fund would have gone back. Therefore, there was no meaning of
thing has
challenging
been,
it. In appropriate thing, we are waiting for the opportunity to challenge it, Lordship. We are waiting for that
That is
opportunity.
okay, but that has been interpreted.
That was in
Something-
relation to the 2020-21 tender process.
That laying down a
It is
policy
regarding uniform. Another aspect is uniform. So that is why the fund was going back. For academic interest, we could have challenged it. But that is not permissible law, because for academic interest, no courts would like to waste their valuable time. In appropriate case, that issue will always come alive. So that is why I'll make an endeavor to place some Supreme Court judgment, as well as to distinguish that judgment that it is not applicable in the present litigation. That will be at the later part of my argument. Paragraph 5. The answering deponent admits that same being matters of record and further state that government and its instrumentalities must have a free hand in setting the terms and conditions of tender unless arbitrary, discriminatory, malafide and actually biased. The participants cannot have a say on the terms and conditions of tender only because the participant feels existence or non-existence of certain terms and conditions would have been fair, wiser, logical, and terms and conditions has to be to his or her requirement to fit into the terms and conditions of the tender. Then paragraph 6, it is basically the SOPD fund we are repeating and also relying upon the 2017 and 2020 rules. Paragraph 8, very categorically we have stated, the answering deponent begs to state that manual on financial management and procurement is not applicable in the present tender process and reiterates that the statements made in paragraph 6 of the instant affidavit in opposition. Pausing here for that observation in paragraph 18 of the coordinate bench judgment, Lordship. Ultimately, this is a commercial transaction. All those equities and other policies will not come into play. Straightway, I can make that submission because this is a commercial transaction. The government will try to save as much money as it can and also to provide the best quality products. It is not feasible for the state of Assam to monitor each and every school of the state where 1400 schools are clubbed together to go and see the quality of the products to be supplied by one individual in each school. It is not practical. And that too in 30 districts. So that was one important area where, for which. Now coming to paragraph 10. The answering deponent categorically denies wild and baseless allegations hurled on the answering respondent deponent. The answering deponent states that the manual on financial management and procurement is not applicable in the present tender process and reiterates the statements made in paragraph 6 of the instant affidavit in opposition. The answering deponent further states that as per notification dated 28/1/2022 of the Government of Assam, Finance Department has made it mandatory that the tender has to be issued through Government e-marketing marketplace GEM portal. This is what I was submitting,
But
Lordship.
to verify this notification is necessary.
Lordship,
To verify this statement, this notification appears necessary.
I'll place it, Lordship. The number is also given. Yeah,
No, we don't have.
yes, I'll place it, Lordship, to all the sides. The notification dated 28/1/2020 of the Government of Assam Finance Department it has been made mandatory and the tender has to be issued through Government e-marketplace. That all procurements of goods and services are to be made through GEM. That accordingly, the present tender is issued and the same cannot be termed arbitrary, illegal, malafide or biased and reiterates the statements made in paragraph 6 of the instant of affidavit in opposition. Paragraph 15. The other case we have said that comes from the central government fund. So basically, these are the facts which we have stated in the affidavit. Now coming to this manual on financial management and procurement. So my learned senior friend, Mr. Chaudhary, placed certain provisions, certain clauses from this procurement manual. And relied upon the letter of 6th August 2018. The letter says it was issued by the Ministry of Human Resource Development.
Yes.
So the Samagra Shiksha and overreaching program for the school education sector extending from preschool to class 12 has been launched.
Which part you are reading?
Lordship, if Lord said, we have, I mean, this way, no? That later, my learned senior friend K.N. Chaudhary placed it, Lordship. So, yeah, that's it, page 53, that's it.
Yes, manual, yes. Yes.
Because they have not annexed the whole document. Yes, that is at page 44. No, I'm sorry, Lordship.
No, otherwise document has been placed in full. Not made fully part of the writ petition,
Yes.
but at a later point of time, this manual running into about
If only this later, yes, money.
more than 100 pages are placed on record. I don't know.
Yes, Lordship. Anyway, that later one is of Manish Garg, the other one is of Reena Roy.
Reena Roy, yes.
Yes. So Manish Garg is also there.
Huh.
What they are trying to say,
This is, okay, let me.
the Reena Roy's letter is of 12th September 2018. And
No, Reena
sorry,
Roy is
Manish
6th
Garg
August.
is 12th September,
Reena Roy is 6th August.
6th August.
So which one is earlier?
Look, both Lordship, I would like to say, because they are not harping upon the state government's policy things. Under the scheme, when it is under the scheme, then these will be applicable. From the language of these letters, it is very clearly discernible. May I read both the letters, Lordship? Let me first read Manish Garg's letter of 12th September
Page.
2018.
Page.
Manish Garg letter at page 44.
Okay, yes.
And Reena Roy's letter, I don't think they have given. As you are aware, the scheme of Samagra Shiksha has been launched with effect from 2018-19 after subsuming the centrally sponsored scheme of Rashtriya Madhyamik Shiksha Abhiyan, Sarva Shiksha Abhiyan and Teachers Education, with a view to provide guidance and uniformity in respect of mode of release and utilization of fund. So first line they have said, more than release of fund. In the instant case, there is no question of release of fund by them. Budgeting and financial reporting. So we don't have to report also to them. Accounting and auditing requirements and procurement procedures. Procurement procedures will definitely it will be preceded by the releasing of fund, budgeting, accounting, etc. in respect of the works done under the scheme. Procurement procedure under the scheme. Now they will have to show where is the scheme under which this particular quantity of furniture is going to be procured. There is no scheme in the instant case. So far as my learned friend Chaudhary's case is concerned. This ministry has developed a FMB manual for the use of the state, union territories and implementing agencies. A copy of the FMP is enclosed and same has been uploaded in the website of MHRD, Ministry of Human Resource Development. Provisions of the manual would be mandatory. Accordingly, it is requested that the guidelines of FMP may be followed in all future financial matters pertaining to the scheme of Samagra Shiksha. In the instant case, so far as SOPD fund is concerned, this particular nodal agency is procuring the goods on behalf of the state of Assam, not on behalf of the central government or Ministry of Human Resource Development of the Union government. So there is a fundamental difference here, Lordship. The source of funding and whether it is under a scheme or it is not under a scheme. In my humble submission, it is not under any scheme of the Samagra Shiksha Abhiyan, SSA. And the other letter also says basically the same thing. May I read it, Lordship? Samagra Shiksha and overreaching program.
1 minute. Yes, next.
Samagra Shiksha and overreaching scheme for the school education sector extending from preschool to class 12 has been launched in 2018 to 2019 with the broader goal of improving school effectiveness measures in terms of the equal opportunities for schooling and equitable learning outcomes. It subsumes the 3 schemes of Sarva Shiksha Abhiyan, Rashtriya Madhyamik Shiksha Abhiyan and teachers education. Pausing here for a moment, Lordship, kindly allow me. Lot of argument has been made on the basis of section 21 and 22 of the RTE Act. Therefore, the school management committee should have complete governance over the affairs of the school. This is what their argument is, and the learned single judge in the coordinate bench also relied upon. Here, one of the school is procuring the furnitures for the upper primary school. The other one is from the lower primary school. And all this manual is for class preschool to class 12. RTE Act is covering only up to the level of class 8, 14 years. So from 9, 10, 11, 12, the RTE Act will not hold the field. This is one distinguishing factor, Lordship. Just it came to my mind, so I've made my mind clear submission. As the scale and scope of implementation of the Samagra Shiksha has increased due to subsuming of the aforesaid schemes, the challenge of smooth implementation and coordination has grown manifold. In order to guide and assist the implementing agencies in program management, the Ministry of Human Resource Development, the Department of School Education and Literacy has brought together procedures, rules, regulations at one place in the Financial Management and Procurement Manual. The FMP manual is intended to be used by the state unitary as a guide for budgeting and finance, reporting procedures, accounting and auditing requirements, procurement procedures to be followed throughout the country. The provisions laid down in the manual are mandatory and are to be followed by the states and union territories to ensure that funds are disbursed, utilized, accounted for in an efficient and effective manner. I fully endorse this statement, Lordship. And all the provisions of the FMP are mandatory in nature. That also will have to consider, Lordship. I am confident that the FMP manual will help the states and union territories to bring financial rigor in the implementation of Samagra Shiksha and prove to be a valuable tool as we seek to realize the goal and objectives of the centrally sponsored program. So the board-
I don't think it will be completed today.
Then may I continue tomorrow, Lordship?
Thursday?
Lordship, from tomorrow, after tomorrow, I'll not be available till the puja, Lordship. So if Lordship give me from 2 o'clock, Lordship, I'll finish it off
Okay, we'll make an attempt. You
Lord.
are not available till when?
till the puja, because from Monday onwards, I'll be in the Supreme Court, Lordship, that 6 says the Citizenship Act day-to-day hearing in before the full bench is listed, Lordship.
Because motions and other things are also there.
Lordship,
I have fixed already 2-3 matters for disposal
Lordship,
in the second half. So we'll try
we'll try.
to make an attempt.
And if Lordship permits these 2-3 documents, I'd like to bring to an affidavit. I'll not add a single word, whatever is there, I'll just place it on record for the other side's advantage also and for the honorable courts also.
Yes, what do you say?
Lordship, only till the time-
Notifications they make.
It should be a part of record, Lordship,
Only notifications.
Only
No-
notification,
no pleading,
nothing
no
else.
pleading.
nothing else. And I'll bring the record. What made record, if Lordship wants to see the decision-making process, I'll place that record also. Because the education department did not file the affidavit, the Samagra Shiksha has filed the affidavit.
Okay. Heard Mr. K. Chaudhary. Right. Heard Mr. K. Chaudhary, learned senior counsel assisted by Mr. N. Gautam, learned counsel for the petitioner in 12. And Mr. K. P. Pathak, learned senior counsel assisted by Mr. S. K. Goswami, learned counsel for the petitioner in 13.
Lordship, if I may, Lordship, in item number 13, Mr. Chaudhary appears.
Okay, okay. K. Chaudhary 13, K. P. Pathak 12. Mr. D. Hoikel, and Advocate General, has not completed his submissions for the respondents, state respondents. First up, raise the cases again tomorrow.
Deeply obvious.
Find out.
Lordship,
I'll give us a
Lordship, the interim order, Lordship.
interim order.
will not do anything. We are waiting for 1 year. One more day will not do anything.
No, Mr. Gautam is very particular.
Very particular. I
He
appreciate.
comes even at 4:15 also. I have seen him. Hey, kiba, beleg kikhon ase niki? List of yes, Mr. Counsel.
I'm taking it.
Yes. Other matters after vacation.
Lordship.
All these are.
Item number 7.
Lordship, item number 7, lengthy material, Lordship.
Lengthy matter, not before vacation now. It will not, there is not time. Okay, it will be left over.
But
It will
Lordship,
be left over to be listed.
Lordship, we'll just fix a date, Lordship.
It will be left over, it will be
Lordship.
listed, all this.